Actually, consider other side. I beg to mention item number 10. The conductive counsel of personal difficulty, Lordship. Matter may fix on Tuesday, Lordship.
Not Tuesday, it will go to next week.
Next week, Lord, on 13 Lord. I'm repeating the other side. Small part, huh?
Oh, it is part heard.
That's it.
Heard Mr.
R. Sharma, Lordship.
R. Sharma, learned counsel for the appellant, who
They're responding. I am for it.
learned counsel for the respondent. Also heard Mr. A. Lal, learned counsel for the appellant. The counsel for the parties prays for an adjournment due to personal difficulty of the conducting counsel for the respondent side. The Mr. Lal, learned counsel for the appellant, does not raise any objection to the prayer, hence the prayer is allowed. Let this matter be listed. When do you want?
13 Lord.
13th of.
Deputy
I'm-
Lord.
Maybe. Well, I have filed an IM in pending civil division petition Milan, and that is filed on 31st of Milan, July. So my prayer it may come on Milan 12th. Milan.
Which case? Which item?
No, that is pending Milan. Today is not listed, but my prayer I have filed, I should be listed Milan. To figure the stay of that.
No, this you have to mention before the senior court for fresh listing.
Senior court in your
There are two courts taking same roster, court number 15 and this court. So you have to mention before court number
I
15.
am thinking your lordship is taking a matter, so civil division. Anyway, I'll think.
May I please, your lordship, indicate to item number 2, lordship, which is started matter, lordship, trial is going on. Today is the date fixed in trial court, lordship. Let us see what happened, lordship, in any PWD, PW.
Heard Mr. S. Munir, learned counsel for the petitioner, who submits that the in the trial court, the case, the concerned NDPS case is fixed today, and therefore prays for a week. How much? 2 weeks,
No 2 weeks, lordship, we'll obtain the copy if any PW.
1 week.
Lordship, can you date, lordship, can it
And-
be on Friday, lordship?
Adjournment for today. The prayer is allowed. Let this matter be. When Friday?
This Friday, lordship.
Let
9th,
let this matter be listed again on 9th of August 2018.
lordship. Much obliged. Much.
May I please, Your Lordship? Your Lordship, I have to mention for listing of an RFA on the day after tomorrow.
Listing you have to mention before court number 15.
It is a Lordship. Lordship, I beg to mention item number 3 and 4, my lord. In this matter, my lord, an NCR in item number 4 has not been received,
Not received.
not received, my lord. So, Lordship, another reminder can be issued to the registry for acquisition of the same.
Heard Mr. M. A. Chaudhary, learned counsel for the petitioner, also heard Mr. D. Das, learned additional public prosecutor. It appears that the trial court record, scan copy of the trial court record, which was called for in connection with AB case number 726/24 has not yet been received. Stop. Issue reminder for the same, registry to issue reminder. Let this case be listed again on
My lord.
20,
20, my lord, 20.
20 August 2000.
Deeply obliged.
Meet with your lordship.
Yes,
Meet with your lordship. Lordship, I beg to mention item number 22, your lordship. The conducting council has some difficulty today, your lordship. May I pray for 28th, lordship?
have you informed?
I've informed the other side, your lordship.
You have informed.
I've informed, lordship, over phone.
Item number 20,
To your lordship.
heard Mr.
N. Gautam, lordship, on behalf of Mr. J. Patwari.
N. Bodhakur,
Gautam, your lordship.
N. Gautam, learned counsel for the respondent submitting on behalf of Mr. J.
Patwari.
Patwari, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. Learned counsel also submits that he has informed the counsel for the petitioner regarding his prayer for adjournment today. Considering the submissions, the prayer is allowed. Let this matter be listed again.
220, your lordship, 20th August. It's a
No,
Tuesday, your lordship.
not a fix.
Before lordship, it can be before.
Let this matter be listed again on 20th August 2024.
May I please, your lordship? So I beg to mention item number 6, lordship. Anticipatory bail application. I believe the case diary has not been received, lordship.
No, CD is not received, my lord.
Heard Mr. V. H. Chaudhary, learned counsel for the
The interim,
petitioner.
sir, no?
Also heard Mr. D. Das, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed again on
29th of August.
29th of August.
Lordship, there is an interim.
The interim order shall continue till next day.
Highly obliged.
My lord, similar in respect of item number 5 also, my lord. In this case also, case there is not received, my lord. They are also on interim, my lord, as it appears from my brief, my lord.
Item number 5, also same order. Interim shall continue. Counsel is Mr. H. S. Bora. Remaining remains same.
On 29th, my lord.
Yes.
Obliged.
Fair play, lordship. Once taken of the respondent side, lordship, I beg to mention item number 25, lordship. The contrary counsel today is some personal legal lordship. Matter will be taken up September 10 or 12.
No fixed date. Heard. Mr. What is your name?
Be ready, lordship.
B. Deori, learned counsel for the appellant who prays for an adjournment on the ground of personal difficulty of the conducting counsel. He also submits that he has obtained the consent of the learned counsel for the respondent side. Considering the submission, the prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry.
That's it.
All right, ma'am.
May I please, lordship, I beg to mention item number 12, lordship. Matter may be adjourned, lordship.
Lordship,
Why?
Lordship, I am for respondent number 1 and 2 in item number 12, lordship. This matter was listed after submitting mention memo by order it was listed. The matter was pertaining to 2012, lordship. They are praying for adjournment. Let the matter be heard our side today, lordship. And if they desire any other day, then their side may be heard, lordship. Not at this stage, lordship.
Lordship, and this contains some personal difficulties, lordship, so.
Maybe our side may be heard.
No,
lordship.
then we'll pass orders when the matter is called. You remain present. When the matter is called, we will pass appropriate order.
Mass of
Lordship. Item number 1.
Kartik Jonait is in. Council of Jonait.
May I please, your lordship.
Yes.
My lord, this is the case of landlord and tenant, my lord. Here, in both the court below held that I am a defaulter. And as well as regarding bona fide requirement also concurrently held in favor of, against the this petitioner, my lord. My lord, can we see the claim, my lord? In the 2 points, my lord, I will show that I am not a defaulter, as well as regarding bona fide requirement also. I will show that there are sufficient stop rooms in of the plaintiff. And others were not evicted. I am will try to evict from the premises. Page 15, my lord, starts from page 15.
No, this is a
Claim
revision. Under what provision?
under 115.
115,
Yeah.
not 227.
No.
Okay.
This point has been decided by some judgments of
Yeah.
Supreme Court. Earlier, there was some controversy. Honorable Justice Ansari again took up the matter and ultimately the all settled.
Division bench.
Settled that revision under 115 will lie.
My lord, kindly see the page 15, the plaint, my lord.
Yes.
That this is the suit for declaration of the plaintiff right title interest over the described in schedule below and for eviction of the defendant from the scheduled land. My lord, here in the case, though they have been filed the case for declaration of right title interest, but basically it is the case of landlord tenant. If we go through the plaintiff's right title interest, then obviously the second appeal is maintainable, not the civil division petition. But basically, this is a case of landlord and tenant case.
Okay.
The plaintiff Bibha Basu Chaudhary and his brother Orup Chaudhary, now deceased, were the actual owner and owner of the premises described in schedule below, hereinafter called the suit room. Originally, the settlement of the room described in the schedule below was made by executing deed of agreement dated 1/8/1981 between the defendant as tenant and the plaintiff Sri Bibha Basu Chaudhary and his brother Orup Chaudhary, now deceased, as landlord. Subsequently, another deed of agreement of tenancy was executed between them on 15/3/1986. Initially, the rent was 700 per month and enhanced to rupees 800 per month by an agreement. That thereafter a partition was made between the plaintiff and his brother Orup Chaudhary, now deceased, and thereby the plaintiff became the absolute owner of the room described in schedule below. That thereafter another agreement for settlement of room described in schedule below on monthly rental basis was made on 6/8/1990 between the plaintiff and the defendant by executing a deed of agreement. That the defendant took settlement of the room described in the schedule below from the plaintiff for a period of 3 years. Condition of payment of monthly rent at rupees 1,000 only, commencing from 1st April 1990. The defendant undertook to pay the monthly rent on or before 7th day of each calendar year, English month in advance, and that the defendant shall make the payment to the office of the plaintiff and shall obtain valid receipts from the plaintiff against such payment. That in compliance with the terms and condition mentioned in deed of agreement dated 6/8/1990, the defendant got possession of the rented room described in schedule below and paid monthly rent of rupees 1,000 per month. That the agreement dated 6/8/1990 ends on 31st day of March 1993. And there was no relevant clause about further renewal, and as such, after 31/3/1993, in absence of agreement in any manner, the defendant is continuing the possession of the room as tenant, and thus he is termed as defaulter and not entitled for any relief in the eye of law. The defendant, by misleading the honorable court and misrepresenting the fact, concealing the filed miscase. This miscase is regarding payment of rent. I will come to later on. That the defendant often created disturbance, causing annoyance to the plaintiff and his people, as well as also all other neighboring people. Those also feel disturbed in carrying out their activities peacefully. That the defendant even defaulted in payment of rent by way of Miss RC case number. It is to be mentioned here that the agreement dated 6/8/1990 clearly stated in para 2 that the defendant shall pay monthly rent on or before 7th day of each calendar month in advance. That the plaintiff is the owner of the suit room, which is occupied by the defendant in an unauthorized and illegal manner, and the plaintiff in dire necessity of getting vacant possession of the suit room from his own and personal use. This is regarding bona fide requirement. The plaintiff is in bona fide requirement of getting vacant possession of the room to get rid of this acute problem for space of his business being faced by him for past long years. Hence, the defendant is liable to be evicted as per law, as the suit room is in unauthorized occupation of the defendant, although the same is being maintained by the plaintiff at his own cost and expenses. Next para is important, that the defendant without tendering, this is important, without tendering any rent for the month of April 1993, illegally alleging that the plaintiff declined to accept the rent filed in Miss J case number so and so, and thereby deposit the alleged rent in court. The alleged deposit is illegal against the provision of Assam Urban Areas Rent Control Act, and no rent was tendered to the plaintiff. That the cause of action of the suit arose on 1st April 1990, thereafter cause of action. Now, two questions regarding bona fide requirement and defaulter. Defaulter part, he said that from April 1993, I paid rent in the court without tendering him the rent, which is prerequisite under section 5 of the Assam Urban Areas Rent Control Act. Now, regarding bona fide requirement also, and regarding this defaulter part, I'll show from the evidence, my lord, evidence is also required, my lord. In the evidence, I have specifically pleaded that in the month of April, I tendered my rent, and on being refused, I paid the rent in court. That part, in both the court below held that I have not made, in the cross-examination, they have asked question that have you pleaded in the plain, in the written statement that I have tendered rent? But this paragraph number 11 and paragraph number 10 is specifically denied in the written statement. And in the evidence, I specifically pleaded that in the month of April, first week of month of April, I tendered rent, refused to accept, so I deposited in court.
How, in WS, how you have denied?
In WS.
In para 11, what was your denial?
Can you see the WS? Page 23.
Para 14.
Para 14.
He has only denied, there is no assertion that he has offered. And that is the finding of both the courts.
That averment made in para 9, 10, 11 are not true and correct. The answering defendant does not admit that he ever defaulted in payment of rent by way of Miss RC case number, and in the agreement dated so and so stated in para 2 that defendant shall pay monthly rent on or before 7th day of each calendar in advance, and the defendant is occupying the suit room in unauthorized and illegal manner, and the plaintiff their necessity of getting vacant possession of the suit room for his own and personal use, and he has bona fide requirement of getting vacant possession of the said suit room, and the defendant without tendering any rent for the month of April 1993, illegally alleging that the plaintiff declined to accept the rent, and as such deposit of rent is illegal and against the provision of the Assam Urban Areas Rent Control Act.
This is the
So
only.
this is the denial. Now in my evidence, my lord, I will show how I have dealt with this point, my lord.
The lordship is hearing a revision. There is no question of reappraisal of evidence.
Yes.
Specific finding of both the courts is very specific. Just one line meaning. My learned friend is reading plain WS. There are 130 pages. My lord, both the courts have come to a finding that there is no pleading, because once the landlord alleges default, it is for the plaintiff, burden is on the plaintiff to show that he has made a deposit,
He tendered the right.
Tendered. Now, Lordship has said this is his statement. He has only denied the statement made in the plain paragraph 11 of the plain. There is no single statement, not a single word that he has offered. And this is the finding of both the courts, my lord. Now, how and
On that ground, the
yes, and
Because-
not only that, my lord, this is one. Secondly, my lord, he has not proved a single NJ case, single. And last 20 years, he's occupying. Sometimes he's paying for 1 month in the court and then he's not paying. And we are suffering, my lord. We have got a nursing home behind. He's on the front. He's obstructing us and he's not paying rent.
My lord, regarding the NJ
Okay.
cases.
Clear finding my lord, by both the
I-
courts that there is no pleading that you have offered. Any amount of evidence cannot be looked into. And there is a.
I'll
I'm
show
just-
from my evidence that I have offered.
No, where is the pleading? Let us come straightway to the point. There is no point when again reading these
My lord,
papers.
it is their pleading
No, no, no.
that I
It is
have.
burden
I
is on
have
you.
paid- Yes,
My lord, I'm just
My lord, I'm
kidding.
coming, my lord.
Burden is on you. Kindly
My
show.
lord, I'm
Just now
coming,
you have
my
said
lord.
that I am showing from the
it
written
is the-
statement.
My lord.
Where
it
is the
my last
statement?
quote. It is, though it is a revision,
No, no, no.
it is my last quote.
whether we
I
can,
love to show.
in revision, we can appreciate evidence.
No,
Yes,
not at all. My lord,
yes, it is appreciated.
my lord,
It can-
question,
it
my
is-
lord,
it
just
is
1
required
minute.
to be
Question of
appreciated.
going to the evidence will not come unless there is a specific pleading on this point. My lord, there
My
is a
lord,
recent judgment.
pleading
I
is
just-
there, my lord.
I want to cut
I-
it short, my lordship. May have a look at the judgment passed by your lordship recently.
No, let him make.
Well, he will make his submission because I have got some of the matters also. The way he is reading the plain, then written statement, then trial court judgment. There's not necessity when
No.
a revision.
Now, he has, one thing he has submitted that both the courts
Yes.
have decided in your favor
Yes,
on the ground that there was no averment
yes,
to the effect that he tendered the
Absolutely.
rent to
Absolutely. yes. Now he has
Landlord.
read reply to paragraph 11. There is no, your lordship has seen, there is no statement that he has offered.
He denied the,
No, denial will not do, my lord. Your lordship is well aware of this law. Denial will not do.
My lord,
You,
in
burden is on
evidence,
you.
I have.
You
I
have to
proved
assert.
That I have.
Where is
tendered
the pleading that you have offered? My
and
lordship will kindly
I
ask my
have
learned
paid
friend to show.
regarding NJ
Where is the
case.
pleading that he has
My lord,
offered?
regarding NJ case, all the
Let-
documents I have proved, and as well as regarding the NJ case, which has not been brought on record, I have applied for certified copy, but that copy were that not traceable from the court. That is why certified copy was not issued. But even then, they have specifically pleaded that I have paid rent in the month of April 1994 without tendering rent to them. That means I have paid rent in court. That much is admitted fact. Regarding tender, I will show from my
statement.
tender evidence.
No pleading.
From the evidence, I will show that there was a tender.
Well,
Paragraph
evidence-
6 of the
well,
evidence
This is
of
what I'm saying.
DWR.
Let my learned friend argue in a legal manner. He has to first show that there is a pleading and then there is an evidence. He is going straightway to the evidence. Where is the pleading, my lord? Where is the pleading?
Pleading-
One line, one word that he has offered.
I have shown your lordship.
You have only denied the
specifically
statement made in para 11 of the plain. Nothing else.
that he has said that I have not offered. That pleading I have specifically denied.
let him complete. How much time you will take?
My lord, then. if-
Only one point is involved, whether it appears that both the courts have decided the case in his favor on the ground that you failed to tender, there was no pleading. You failed to assert in your written statement that you tendered the,
My lord, kindly say again, I'll read the
Let him
paragraph
show
again.
one line,
I'll-
man, one word.
11, paragraph 14.
in para 14, you have denied the.
Denied his abutment that I have not tendered.
That's not
Okay.
enough.
Then
So-
in the evidence I laid that I have tendered.
Sure.
This is the paragraph 6 of the DW1. my lord.
No, what was the finding of the trial court?
Trial court says that there was no pleading in.
Where? Take me to that
Yes.
specific finding.
Page
of-
70, my lord. 70. Issue number 7 and 10 taken together, my lord, in respect of defaulter.
I'll hear you. Let him.
My lord.
My lord, whether your lordship is disposing of these cases,
Yes.
then I will have to give full opportunity to heard before hearing the.
Let him have
respondent
full
side.
What
I'm
is-
not saying that.
Because at the
Let-
midst
let-
of
let
this,
him
midst of the argument, if respondents are arguing,
No,
then I
he will
will,
not. we are disposing of this matter today.
Then I will full-fledged argument I will make.
Yes, but what is your ground in this revision petition?
Revision petition basically two ground. The ground regarding tendering of the rents in the month of April 1993
Was not
is
considered.
perverse. It is not considered the evidence of the
You take me directly to that ground. And what else?
regarding bona fide requirement, I will show that there are other several rooms in
Bona fide requirement,
Both-
on both the ground?
Well, both.
both the ground.
Okay.
My lord, kindly page 28 judgment. Page 36 and issue in the suit. I am not reading the facts, my lord. I am straightway going to the issue in the suit. In
Yes.
view of the antipodal pleadings of the parties, the following issues were framed.
Issue number 7 was,
Whether number one, is there any cause of action? Whether the
other issues, there is no much dispute except issue number 7.
does
I-
not the defendant tendered monthly rent for the month of April 1993 to the plaintiff? Then issue number 10,
Issue number 9,
10,
10.
9 and 10.
7 also.
Yes, how it was decided?
My lord, kindly go through the page number 45. Regarding NJ cases, whether I have been called for all these NJ cases or not, that I will show from this
No, what was the finding?
finding I am coming, my lord. My lord, then kindly see page 50, my lord. Exhibit D is the certified copy of the
Which page?
page 50.
Yes.
Exhibit D is the certified copy of the challan showing payment of rent in the month of September and October 2005, Miss case number so and so. Exhibit D in order dated so and so passed in Miss case number so and so. Exhibit E are the certified copy of petition. This is
Who-
important from 32. These are the petition dated 31/2009.
How many witnesses were examined by defendant side? Only one?
Only one.
Okay. DW1.
On 5/1/2000 seeking for furnishing the certified copy of the rent deposit receipt and last order passed in various miscases, but these sought for document were not furnished, for which he had to file petition for obtaining certified copy of the petition exhibit so and so so and so. And he is submitting application for obtaining the copies of exhibit so and so dated so and so, and accordingly copies were sought for were furnished to him. Be it mentioned here that the petition number so and so are already lying in the case record, which were submitted along with the petition dated so and so, containing the list of Miss RC case number. The endorsement made in the copies of the petition seeking in certified copies so and so. Exhibit E so and so will bear out of the fact that the records of some of the documents, this is important, were destroyed, for which required copy were not furnished. He further stated that as per clause 2 of the agreement dated so and so, the monthly rent was payable in advance, and accordingly in terms of clause number 2 of the said agreement, the rent for the month of April 1993 was deposited by Miss RC case number so and so. The endorsement made in the copies of the petition seeking for certified copy by exhibit so and so will bear out the fact that the records of some of the documents were destroyed, for which required copies were not furnished. He further stated that as per clause 2 of the agreement dated so and so, the monthly rent was payable in advance, and accordingly in terms of clause 2 of the said agreement, the rent for the month of April 1993 was deposited by Miss RC case number so and so on 12/4/1993. This is the important date. In 12/4/1993, I paid rent in the court. And as such, there can be remain no scope for defaulter on payment of monthly rent for the use and occupation of the tenanted room of room number 7, room number 5. An allegation made in the plaint as to the default of payment of monthly rent is absolutely false and made with the intent to mislead the court. He also stated that title suit number so and so was decreed ex parte on 11/4/2008, and the said decree on being challenged in court number so and so, Silchar, by filing title appeal number so and so. After hearing both the parties were pleaded and deposed that title appeal number so and so, by setting aside the judgment and decree dated so and so passed in London Munsef Silchar, Kachar, remanding the title suit number so and so for fresh trial by the order dated so and so. Exhibit F is the certified copy of the judgment dated 11/11/2009, passed in title appeal number so and so. Since such remand of title suit number so and so, he has been delightedly contesting the suit, but plaintiff on one plea or other has been delayed the case by filing abrogative appeal against order dated so and so before the court, which was subsequently withdrawn by the plaintiff. He stated that prior to adduce the evidence by the plaintiff, a petition was filed by seeking for calling of various RC case from the office of the court, and by order dated 7/5/2013, the said petition was rejected, holding inter alia that he will getting chance to produce the RC cases at the time of adducing his evidence. Subsequently, he sought for calling of the record of Miss RC case for proving the deposit of rent of various Miss so and so, but the plaintiff vehemently opposed it, and accordingly he was not allowed to call for the records by order dated 11/1/2017 to prove the deposit of rent for the month of April 1993. By not allowing his petition for calling of Miss RC case number showing payment of rent for the month of April 1993 and other following month, he was handicapped, and subsequently closing of the evidence, he was rather compelled to file a petition on 19/6/2019, and this court, on being moved, was pleased to pass order on 18/9/2019, allowing him to adduce evidence by way of examination in chief with cost. And in view of the said order, he is submitting his examination in chief by way of affidavit along with his document, marked exhibit and annexures. The plaintiff in the meantime has constructed an RCC floor. This is also important. RCC floor over the existing ground floor where tenanted room 5 is situated, and has been constructed a big commercial RCC 2-story building accommodating more than 100 rooms. So there are 100 rooms name and style Elora Market, which are being used as a shop and have been let out to various people, generating more than few lakhs of rupees as a rental income. So about 100 shop rooms, out of 100 shop room, I am given one room. The plaintiff has also a nursing home at the back of the tenanted room 5 named style as Elora Nursing Home, which was run and managed by the original plaintiff, that is so and so. And consequent upon his death, the said nursing home is now run by and managed by his son, the submitted plaintiff so and so, who is an ophthalmologist. It is pertinent to mention here that the son of the original plaintiff is also serving in another nursing home in Kolkata as a medical practitioner, and as such there is no pressing bona fide requirement of the plaintiff to get the vacant possession of the said tenanted room. Rather, he is in dire need of the suit premises, that is shop room number 5, for genuine income, for generating income, for running his family and urgent medical treatment of his only son, who is suffering from severe cardiac problem. So 2 points I have shown regarding regarding the defaulter part, and another is bona fide requirement. Now kindly come to findings. Page 60 is the discussion, decision and reasons thereof. Page 67 can. Issue number. Page 70. Issue number 7, does not the defendant tender monthly rent for the month of April 1993 to the plaintiff? And issue number 10 is defendant defaulter in any way. Lordship got it?
Yes.
Page 70. The plaintiff in his plaint and examination in chief has stated that after the tenancy agreement dated 6/8/1990 executed between the plaintiff and defendant number 3 year marked as so and so, the monthly rent was fixed at rupees 1,000 per month coming from 1/4/1990, and accordingly the defendant under the agreement, the defendant undertook to pay rent for each month on or before 7th day of the same month according to English calendar in advance, and the defendant was to make payment to office of the plaintiff and shall obtain valid receipt from the plaintiff against such payment. The period of tenancy would get over as per Exhibit 3 on 31/3/1993. In Exhibit 3, there was no provision for further renewal as such after 31/3/1993. In absence of agreement, the defendant continued for unauthorized occupation. Further, the defendant did not offer any rent for the month of April 1993. The defendant made some rent deposit in court without offering rent to the plaintiff. The defendant cited in his written statement as well as DW1 in his examination in chief stated that, this is important, my lord. DW1, his statement as well as DW1 in his examination in chief stated that he tendered the rent for the month of April 1993. However, the plaintiff refused to receive the rent in order to make him the defaulter in respect of payment of monthly rent, and accordingly the payment of monthly rent for the month of April 1993 was deposited in court by case number so and so, and since then defendant deposited the rent in court. In his cross-examination, the defendant has stated that in his cross-examination he had not specifically mentioned the tendering of any rent to the landlord for the month of April 1993, and the landlord refused to accept the same. In this regard, the relevant provision, this is regarding provision, section 5. It can be skipped, my lord.
No, there is some wrong. In his cross-examination, the defendant has stated that in his written statement, it should have been perhaps. You read this line.
Yes. In his cross-examination, the
Sir.
defendant has stated that in
Sir.
his cross-examination.
Again, in his cross-examination, what he is referring to. In his cross-examination, the defendant, let us,
Stated that, that is why I want to show the cross-examination as well as the plea.
yes,
part.
what,
In
in the cross-examination, what defendant has
has said,
stated?
yes,
That he has not mentioned in written
Yes.
statement. Only read that line, relevant line,
it is not mentioned in the written
in the
statement
written statement.
and filed by me that
Okay,
I paid
so,
rent.
so in page 71, instead of cross-examinations,
It should be written.
written statement,
statement.
it should be written
Yes.
statement.
I paid rent for the month of April to the landlord.
Okay, now again come to 71, page 71. You
71.
71. That during cross-examination, DW1 has specifically
Mention.
mentioned that he has not mentioned in his written statement regarding tendering of rent
Yes,
to the landlord.
yes. It is in cross examination.
Yes,
Question was in the cross examination then whether it has specifically mentioned in the written statement or not.
yes,
That was the question, and he said that
I have not mentioned.
specifically, I have not specifically mentioned. And in the chief, my lord, in the chief part, paragraph 6, he has specifically mentioned that he has tendered rent. Then chief
No.
part has not been read out.
That is the
No,
problem.
their plea is different. Their plea is, your evidence is without pleading.
Yes.
Yes.
That is
Their
their-
plea is without
On
evidence.
that you addressed me,
Yes,
that whether evidence without pleading can be accepted.
accepted, yes.
Only that is the.
Now kindly see then written statement, my lord.
Yes,
Written statement,
written
Whether-
statement you have read for para 14.
para 14. There was a specific apartment that I have, their specific apartment in the plea that without offering rent, I have paid rent in the court. That was
And you have denied that.
specific denial. It is not correct.
So it covers,
It covers.
that is your submission.
Yes. That is my submission. Because they are specific pleading, I have denied, specifically denied.
What trial court held in this regard?
In this regard. Now, it can be, kindly see, trial court held at,
Page 71.
73.
73.
71, my lord, regarding section has been quoted,
Okay.
then section 5 has been quoted, 72, kindly see 73. Now coming to the instant case in hand, it appears that the defendant has nowhere shown and proved that tendered the rent and plaintiff refused to accept the rent. This is the finding. Now further, it is also pertinent to mention that defendant never called for original record of Miss RC case number so and so. This was also finding is not correct, my lord. Which was for depositing the rent for the month of April 1993. I have called for, that has been rejected. And the certified copy I have applied, they have, reply has been given that the record is not traceable.
Then how have you proved that you tendered? Without calling NJ case? And
No,
without,
NJ case regarding my submission.
neither you have
regarding
produced the NJ case
I
nor,
have to prove with the, in the NJ case, my lord, I have, whether I have deposited or not.
yes.
I have deposited or not. In their pleadings, they have stated that, yes, I have paid rent without offering them. That means payment of rent is not disputed. Now, whether it is a valid tender without tendering or without tendering.
Okay.
Now, in my evidence, my lord, I'll person this evidence. Paragraph 6. I may read slowly, my lord.
Which,
I stated that first party, though accepted.
where are you reading?
It is not on record, DW1, my lord. I'll give the copy, my lord. I stated that first party, though accepted the rent for the month of March 1993. But
Whether this can be disposed of without records?
My lord, the trial
Because if
court
this issue is there,
Well-
evidence, you have annexed the evidence of DW1.
my lord, then
My lord,
I'll file the.
my lord, the trial
DW1
court's finding is,
by
there is, let's just make one sentence. Trial court's finding found by the first circuit court is, there is no pleading that he has offered rent,
Only on that.
only on that. Now, for that, my lord, your lordship has to go to the pleadings, that is written statement. Written
is there.
statement, my lord, he has only denied the statement made in paragraph 11 of the plaint. Matter ends and record is not necessary for that, my lord.
Okay.
My lord, may I read?
Yes, please.
I stated that first party though accepted the rent for the month of March 1993, but subsequently he refused to receive the rent for the month of April 1993 and was well blamed upon me to make me a defaulter in respect of payment of monthly rent, for which I could apprehend the same, and for saving myself from the menace of being a defaulter in respect of payment monthly rent for the month of April 1993, I deposited the same in Court White RC case number 46 of 1993, and the same was received by the Treasury and Bank on 12/4/1993. After the same being verified by the Serestadar of the Court of Assistant so-and-so Kachar Silchar on the same date on 12/4/1993, and thereafter, though the rent for use and enjoyment of the shop premises for the month of May 1993 was duly tendered to the predecessor interest of the plaintiff from time to time, but on his refusal to accept tender rent, I had to
Okay,
deposit the rent
okay.
for the month of
No,
May.
that they are not disputing that you, in your evidence, you said
That I am not disputing.
that they are not disputing what I understand.
Yes.
They are only disputing that you have made no pleadings to the effect that you tendered your rent
In the
to
written statement,
in the written statement.
in the written statement.
So your evidence is beyond pleading, therefore it is not,
It is,
that is their difference.
yes.
On
But
that, what is your submission?
my submission is that when there is a pleading on the part of the plaintiff, that I deposit rent without offering or without tendering them in the month of April 1993. So this
And
part,
if you deny
that part, without offering part, I have denied.
that
Denied.
means you have offered.
Offered.
Indirectly, it means that you,
That I have offered,
okay, that you want to submit.
yes.
Okay.
And by way of evidence that I have proved that
Okay.
I offered the rent.
And regarding bona fide requirement, what was the finding?
There is, my lord, kindly see bona fide requirement part.
Page? Nine.
Case 74, my lord. Has the plaintiff any bona fide requirement of the suit room? Lordship got it.
Yes.
The plaintiff in his claim has stated that he has dire necessary for getting vacant possession of the suit room for his own and personal use, and he is facing acute problem for space of the business. Further, PW2 in his examination in chief has stated that after death of his father, the original plaintiff, Dr. So-and-so, he was compelled to shift in Silchar to look after the family and protect the interest of Hillora Nursing Home. He further stated that he too a doctor by profession, and he is bona fide requirement of the tenanted premises. In this regard, this is, judgment has been quoted. After next page 6, after going through the above judgment and materials available on record, it can be concluded that plaintiff is bona fide requirement. There is no findings,
No
there is
discussion.
no discussion. And so far is, and it is a trial court, my lord. Now appellate court can speak.
At page?
Appellate court has framed point for determination. my lord.
Page number?
Point for determination, my lord, at page number
Page 107. 109.
Page 111 and 83. The learned counsel for the respondent plaintiff had further argued that although the appellant as defendant had stated that he had paid rent for the month of April 1993 to the landlord, but during his cross-examination, the appellant DW1 admitted that he had not submitted any document to show that he had deposited rent from April 1993 to December 1995 and from 1996 to December so and so. The learned counsel has further argued that the appellant defendant has also not submitted any document to show that he had either tendered the rent to the predecessor of the respondent plaintiff or to the respondent plaintiff had deposited rent from 2019 to October 2021 and for subsequent period thereto. Learned counsel for the respondent plaintiff has further argued that although defendant number DW1 had exhibited some document marked as exhibit so and so, but in cross-examination, the appellant as DW1 had admitted that the aforesaid documents were not relating to payment or deposit of rent. The learned counsel, other document has not been discussed, other exhibit. The learned counsel for the respondent plaintiff had further submitted that as the appellant defendant failed to prove that he had deposited rent to the respondent plaintiff by exhibiting proving NJ cases, he is a defaulter and is liable to be evicted from the suit premises. Then section 5, it can be skipped. Now, page 114. When the landlord refused to accept the lawful rent offered or tendered to him by the tenant has to deposit the rent together with the process fee for service of notice upon the landlord. And on receiving such deposit, the court will cause the notice of the receipt of such deposit to serve upon the landlord, and landlord can withdraw the amount by making an application to the court. My lord, one point in PW1 I will show that with respect to NJ cases, they have also filed objection in NJ cases after receipt of notice. A tenant can claim protection from eviction only in case of the rent in paid or deposited in accordance with the provision of section 5 so and so. Then paragraph 97 and 98. I have perused the written statement of the appellant defendant 116. I have perused the written statement of the appellant defendant which he had filed title suit number so and so, and on perusal of the same it appears that appellant defendant had not stated in his written statement that he had either tendered rent to the predecessor of the respondent plaintiff or had deposited rent in court by following procedure mentioned in so and so 5(4) of the Assam Urban Areas Rent Control Act. After the predecessor of the respondent plaintiff had refused to accept the same. Moreover, the appellant defendant had admitted in his cross-examination DW1 in title suit number so and so. Then tenancy agreement, then these are the now kindly see 106, my lord. Page 117. I have not submitted any document to show that okay. Paid rent from the month of April 1993 to December 1995. However, I have applied for certified copy, but that was not furnished to me. I have not submitted any document before the court to show that I have paid monthly rent of landlord from 1996 to December 2001. nor I have submitted any document to show that I have deposited rent in court for the said period. All this, this is not on beyond the record, my lord. In the record, contrary, I have shown all these documents,
No, this is the
submission,
court is quoting your cross exam,
cross-examination part,
quoted from the cross exam.
cross-examination part.
Where is the finding? 118.
My lord, is cross-exam.
Para 118.
Yes. My lord, I am personing the cross-examination part
Okay.
of DW1.
Otherwise, cross examination is quoted in the appellate court's judgment also.
Yes, kindly see.
Yes.
Now 118 paragraph. Bare reading of the written statement of the defendant indicate that he had not mentioned in his written statement that he had tendered rent to the predecessor of the respondent plaintiff for the month of April 1993. The written statement also does not reveal the appellant defendant had mentioned in his written statement that appellant defendant tendered the rent for the suit premises to the predecessor of the respondent plaintiff so and so or to respondent plaintiff from April 1993 till the filing of the written statement on 2/8/2004, and on refusal of the predecessor of the respondent plaintiff because or respondent to receive a same deposit the rent for the suit premises in the court after complying the provision of so and so. Moreover, the defendant had admitted in his cross-examination that he had not submitted any document to show that he had tendered rent to the landlord and on refusal deposit of rent or paid rent. There is in the question in the cross-examination only line is that in the written statement I have not stated the tendering rent.
But you read page 117, para 106,
Yes,
where you have stated that I have not submitted any document to show that I have deposited rent in the court.
that record, my lord. That is why I am saying that the LCR is necessary, because in the LCR there is an exhibit regarding NJ cases, regarding not traceable
No.
cases also.
The question is whether in your cross-examination, have
Cross-examination.
you stated so? In cross-examination, you have stated so that you have not submitted any documents. In your cross-examination, you are saying that to the court that you have not submitted.
I have. But on record, it is there, my lord. On record as well as in chief also it is there, my lord.
Now, what is your submission?
My submission is
Where
that whether
what was the error of the first appellate court as well as trial?
error, my lord, error is with respect to
The first appellate court as well as trial court based its finding on the ground that there was no pleading to the effect that you
Tender.
tendered the rent
tender the rent.
and you failed to show any document to prove that you have tendered the rent you have deposited the rent in court.
Regarding deposit part, my lord, there is no deposit. Since they have specifically pleaded in the plaintiff that I have deposited rent.
Okay.
So far deposit is concerned, there is no dispute. Only dispute is tendering part.
Now, what is your submission?
Regarding tendering part, my lord, in the chief of my DW specifically pleaded,
It is there.
it is there,
Assuming that it is there.
it is there. So,
Whether it is admissible
my lord, my submission,
without pleading.
it is not without pleading. My submission is, it is not without pleading. Since
In
there is
paragraph 14 of your
14 of the-
WS,
yes,
you have pleaded
pleaded
by denying the.
by denying their requirement that I have not tendered.
Okay.
And regarding bona fide requirement, my lord, there is finding has not been discussed, my lord, nothing in elaboration. And in the evidence is there that there are other shop rooms also, about 100 shop rooms.
In
Only
a,
I have been chosen to,
in a civil revision under 115 against first appellate court's judgment, what are the limitations on?
limitation is that one, jurisdictional error. Number two is the perversity. Whether the materials available on record has not been discussed in its proper
So-
perspective. The language is
What you are pressing in this? Because there is no jurisdictional error.
jurisdictional part, I am not saying, I am saying with respect to error apparent on the face of the record.
Okay.
115, my lord, exercise jurisdiction not vested in it by law. A, to have failed to exercise jurisdiction so vested, or to have acted in exercise of jurisdiction illegally and with material irregularity. Here in this case, and with material irregularity, the learned court below have been decided this appeal, my lord.
Okay.
Regarding materials, my lord, the various exhibit I have exhibited, including NJ cases, including not traceable certified copy I applied, I produced that also, that not traceable,
You have exhibited NJ cases also.
yes. That is why I have read out the earlier part, my lord, regarding paragraph, page, my lord, 50. What are the documents
No,
I have,
NJ cases regarding April 1993.
my lord?
April 1993.
No, April 1993 is, first of all, my lord, I have called for the record of April 1993.
No, assuming that there is a default in April 1993 and thereafter you are regularly paying rent in court, then also there is a
Then also
default.
I
There
am
is a
defaulter.
default.
Then also I am.
So
defaulter.
they are pressing on April 1993 rent.
My lord,
So
April 1993's record I have called for. That was rejected. Then I have applied for certified
you have
copy.
not challenged that rejection order
No, I have not challenged.
and you have applied for certified
For
copy
copy,
where it is informed that the records are not traceable.
not traceable.
So ultimately you fail to exhibit anything.
Certified
Regard-
copy has not been provided.
Okay.
Certified copy has not been provided, so I have, but at the same time, my lord, it is an admitted position that in April 1993, I paid rent. It is not disputed. Kindly go through the plain, my lord. Plain kindly see. Plain paragraph, one paragraph I am reading. Paragraph 11,
At page
17. That the defendant without tendering any rent for the month of April 1993 illegally alleging that the plaintiff declined to accept the rent, file case number so and so, and thereby deposit the alleged rent in court.
Okay. So that deposit of rent in court is admitted by the
Plaintiff,
plaintiff.
yes,
Only tendering
only tendering part.
they are challenging. Okay.
And with respect to this
Okay,
tendering
what
part,
else is your submission?
my submission is with respect to tendering part, I have denied that no, it is not correct. And in evidence, I stated that, yes, I have tendered the rent, then thereafter I have paid the rent in court. And so far bona fide requirement is concerned, there is no discussion, my lord.
Okay. You are relying on any authority regarding how to interpret the pleadings?
Legal. That I will submit, my lord. Right now, I have not got.
Okay. Yes, Mr. When will you give? You are relying on any judgment?
My lord, I'll produce later.
How they will
During the
know
course of
what
the
you,
day, I will copy to them. Today I have not, actually I thought that today hearing may not be.
what was your,
that is-
okay. No, today you are anticipating that it would be admitted,
Yes.
then you should have made that submission.
My lord, there is
Yes.
a, now things have changed. There is a trend that in landlord tenant cases where we find that there is a clear finding of fact about defaulter, well, we concede and we pray for time. And there is a reason why I'm raising objections only. This is the case where, so far as the default is concerned, it is absolutely fair finding recorded by the learned trial court that there is no pleading with regard to tendering. My learned friend is going to the evidence, my learned friend is going to the some admission somewhere. Well, these are all irrelevant. What is relevant is for the first month of default alleged in the plaint, the defendant must come forward and say that there was an offer, refusal, then deposit in terms of the provisions of the act. Now, my learned friend is arguing repeatedly that there was a pleading in para 11 of the plaint that he has deposited rent without offering, and he has denied that. Now, he wants to say that this denial in the written statement would be
No.
enough for the purpose of discharging his duty of pleading that he has tendered before deposit.
Yes.
Now, here is a case, had I admitted in the plaint that he offered and then he made a deposit in the court, then this kind of denial would have to some extent helped him. My pleading is very clear that he has deposited without tendering. Without tendering, and this is what he has denied. This does not, my lord, fulfill the requirement of law that you should, because law is very clear. My learned friend is well aware. He has argued so many cases on this landlord-tenant matters that whenever a landlord alleges default, it is the entire burden is on the defendant tenant that he has offered, that he has deposited and deposited within time. And my lord, your lordship is aware, this NJ case, mere deposit will not do. The NJ cases must be legally disposed of. If he has not taken steps for proper disposal of the NJ cases, that will amount to default. Your lordship is aware of that, man. Now, here is a case, my lord. He has simply denied the statement made in the plain, and in the evidence, my lord, he wanted to improve by saying that no, I was offered. When he has offered, to whom he has offered, how he has offered, there is nothing but then one word is that he is offered. Now, my submission is very simple, my lord. This evidence which he has brought in the oral evidence, my lord, cannot be looked into. In fact, he cannot be, should not have been allowed to lead this evidence by the trial court itself. Law is that no amount of evidence should be allowed to be led, which is not supported by any evidence. Now, the judgment which I have submitted just now, your lordship had the occasion to deal with this same in a very recent case in possibly in Nagaland, arising from Nagaland, my lord. Just lordship may have a look at page para 24. Para 24, at page, internal page 11. My lord. At the bottom, then page number is there. Para 24, your lordship has got, my lord.
Yes.
It is submitted by the learned senior counsel for the appellant that no evidence is permissible to be taken on record in absence of pleadings to that respect. And no party may be permitted to travel beyond the pleadings, and in support of his submission, learned senior counsel has cited a ruling of Supreme Court of India in the case of Union of India versus Ibrahimuddin, this famous case by Ibrahimuddin, 2012-86. And then next page, lordship, can I kindly turn to the next page, my lord. I have not brought all the judgments of Ibrahimuddin and all other cases. It's not necessary because everything has been discussed here. Next page, lordship, may kindly have a look, madam. First line, based on grounds outside the pleadings of the parties, no evidence is permissible to be taken on record. And the trial court ought not to have allowed the defendant to lead that evidence, saying that
Okay,
no.
no, it is not disputed that pleading beyond, the evidence beyond pleading is not allowed.
Yes.
The question which is involved in this case is whether he should have made specific averment that I have tendered my rent
My lord.
or mere denial is enough.
My lord, the word specific, my learned friend is used. There is no requirement of using the word specific. There is no averment at all. It is another thing to say that there was some statement, but it was not specific. He has only denied the statement made in the plaint. And it is not a case in the plaint that I have said something with regard to offer.
No, but by denying your averment, where
Right.
you have in your plaint averred that he did not tendered any rent,
No. Yes, yes,
by denying that averment,
my lord.
whether it amount to saying that I tendered the rent. That is the question to be decided in this.
My lord, possibly it will be going too much, my lord. He has to specifically plead. By denying a statement made in the plaint, it doesn't suffice, my lord. He has to plead that I have offered the rent. Where is this statement in the written statement that he has offered and it was refused? He has only denied the statement made in the plaint. And my plaint case is very simple. He has deposited without offering. That he has denied. But he has to, mere denial will not do. He has to assert that he has deposited and prior to deposit he has offered and there was a refusal. My lord, I'll take your lordship to one or two provisions of the civil procedure code which will be relevant here, my lord.
Yes.
Lordship may
CPC
kindly have a look at order 8.
CPC blue color at the CPC. yes. Mhm. Mhm. Belek DQ. সিভিল বেঞ্চ ওয়ানত CPC না থাকিলে দাবী কৰে। Blue color CPC. Yes, yes. Yes, order. Which provision?
My lord, order 8, rule 2, lordship may kindly see first, my lord.
Order 8, rule 2.
My lord.
Yes.
It says the new facts must be specifically pleaded. The defendant must raise by his pleading all matters which show the suit not not to be maintainable or that the transaction is either void or voidable in any point of time. And all such grounds of defense. Lordship may kindly see order 8, rule 2. My lord.
Yes.
I'm again reading, my lord. The defendant must raise by his pleading all matters which show the suit not to be maintainable or that the transaction is either void or voidable in point of law. And all such grounds, this is important, my lord, of defense, as if not raised, would be likely to take the opposite party by surprise or would raise issues of fact not arising out of plaint, as for instance, fraud, limitation, release, payment, performance, or facts showing illegality. So it is his case that my deposit was preceded by an offer, which he is trying to develop in the evidence. He has to specifically plead it.
No, he order 8, rule 2 is applicable
My lord.
if nothing is mentioned in the plaint. If there is no mention in the plaint, in this case, you have mentioned in your plaint that he has not
My lord,
tendered.
my lord,
and-
there is, my lord, subject to correction, my lord. My case was that there was no offer. To be specific, my case was there was no offer.
Yes.
Now his defense is
He
there was
denied
offer.
it.
No, he is denying that there was no offer. He is denying that there was no offer.
Whether that denial would mean that there was an offer.
My lord, my
By
humble-
mere deny, when you say that there was no offer
my lord,
and without offering, tendering the rent to me, you deposited in the court.
my lord.
He denied the entire averment.
Yes, entire
Why?
event is,
My query to you is,
my lord.
by denying your averment, whether he means that there was an offer
My lord, my submission will
and
be,
whether under such circumstances, he can lead evidence to
my lord,
prove that.
absolutely, I have understood the question. My lord, my submission before lordship will be, mere denial of the plaint averment will not do, number one. And number two,
Yes.
when his case, which he has tried to develop in the evidence is that he has offered, he must make a specific averment in the written statement that he has offered the rent.
Okay.
It is his defense that I have deposited after offer and refusal. He must plead it,
Under order 8 rule 2.
my lord. My second submission is, lordship is aware, for the first month, he has to prove that there was a refusal and then offer, deposit in court. For the subsequent months, my lord, he again need not, there is a judgment, your lordship is aware on Justice Pataki, that for subsequent months, he need not again and again prove refusal, he can simply make a deposit. But law requires that you should deposit, you should prove the deposit of rent for all subsequent months by calling for the NJ cases and proving them. My lord, there are statements in the judgment I'll show, my lord. He has submitted photocopies of some deposit of rent. And now he's raising a plea that I called for the record, he has objected. You had every right to come before the Honorable High Court to say that I filed an application for calling for the records, and there was an objection, and the court also accepted the objection. I know your lordship is aware, your lordship had a vast experience. What we normally do is we just give a list, either we call for the records or we submit a list of in the witnesses where we want to examine the Seristadar, and he is in the summons asked to produce the NJ cases, and he proves that. That is the law.
Okay.
In this case, there is no submission on behalf of the petitioner before lordship that these documents with regard to deposit of subsequent months were deposited in court or were proved in the court. Now, finding of the court, lordship may kindly have a look, very clear. Page 70 for the trial court, my lord. Discussing everything, my lord. Page 72, I would like to just point, because I have not brought the judgments, because these are already referred here, and you are only, my lord, it's very hackneyed by now that these are the judgments relevant for this ejection suits, my lord. Page 72, my lord. This judgment of Keshav Chandra Sinha at the bottom, my lord, whereby it was held that a tenant has a duty to prove that the landlord refused to accept the rent on being tendered. In the absence of an offer and refusal.
Yes.
My lord, here I would like to pause for a moment. Two things he has to prove, my lord. Two things he has to prove by making a pleading, that there was an offer and there was a refusal. I have made in the plaint a statement that without offering rent, he has deposited. I have not said anything about refusal. He has denied the statement with regard to deposit of rent without offering. What about the refusal, my lord? He has to prove offer, refusal, and then deposit. So far as the refusal is concerned, I was silent in the plaint. And there is no question of denial of the question of refusal. But he had a burden to prove refusal also by making specific pleading. What will happen to that, my lord? The judgment is very clear.
This aspect, refusal aspect was not considered by trial court and
Trial court is, my lord, should not go to the refusal aspect because trial court has held that there was no offer. And there was no statement in the plain, my lord, very written statement, it's very clear, page 73, Lordship may kindly see. Relying on that Rupchand Daftari case where, my lord, it says without tendering rent, you should not, the requirement of section 5, subsection 4 of the Rent Control Act is not fulfilled. Then second paragraph, my lord. Now coming to the instant case in hand, it appears that the defendant has nowhere shown and proved that the land that he tendered rent and plaintiff refused to accept the rent. This is there. Nowhere shown that there was a refusal. This finding is there, my lord. Next paragraph, my lord. Further, it is also pertinent to mention that defendant never called for the original record of Miss Arce case numbers so and so, which was for depositing the rent for the month of April 1993. Then, Lordship will kindly see the appellate court's finding. That is in more detailed manner. I straightway go to page 116, my lord.
yes.
Para 98, two paragraphs I'll read, my lord. Para 98 first, my lord. I have perused the written statement of the appellant defendant which he had filed in so and so. On perusal of the same, it appears that the appellant defendant had not stated in his written statement that he had either tendered rent to the predecessor of the respondent plaintiffs or had deposited the rent in court by following the procedure prescribed. Meaning thereby, procedure also includes the part of refusal. Section 5 of the Rent Control Act, after the predecessor of the plaintiff had refused to accept the same. So refusal has been discussed here also. You have to offer, there has to be a refusal, and there has to be a deposit within 2 weeks, madam, from the due date. Now, para, my lord,
Yes.
my lord, may kindly see. Para 99, it is mentioned that moreover, the appellant defendant had admitted in his cross-examination as DW1 in title suit number so and so that, now this is a quotation from the cross of DW1, I'm sorry. Then Lordship may kindly turn to page 118, para 109. First 107, my lord, on top. I have not submitted any document before this court to show that I have paid monthly rent to the landlord from 96 to December 2001. So for years together, he is occupying the land, creating all sorts of nuisance, and then he is not paying rent also. Then para 109, my lord. This statement is also important in the cross-examination. In my written statement, nothing has been mentioned that I have paid rent to the landlord for the period from April 1993 till filing of my written statement on 2/8/2004, nor anything has been mentioned regarding deposit of rent in any court for the said period from April 1993 till filing of my written statement on 2/8/2004, nor anything has been mentioned regarding deposit of rent in any court for the said period, that is from April 93 to July 2004. Almost 10 years. It is a fact that in my written statement, I have not specifically mentioned regarding tendering any rent to the landlord for the month of April 1993 for subsequent month, and the landlord refused to accept the same.
And your submission is that specific mention has to be there.
Has to be there. This is by way of a denial of an averment made in the plaint. It will not be enough, my lord, number one. And number two, my lord, as far as refusal is concerned, there was no averment in the plaint because since I said there was no offer, he had the burden also to show that there was a refusal. Because unless there is a refusal, there is no question of deposit. As far as my lord, the finding with regard to bona fide requirement is there, is concerned, my lord. Your lordship has seen in the trial court has mentioned about the the case pleaded by both the parties. And then, my lord, lordship
Have
may
not
kindly-
discussed.
in too many words, there was no discussion, but then the trial court has come to the kind finding, relying on that judgment of my lord, which says that Pratibha Devi,
No,
that
but how
landlord is
that
the best
judgment,
judge.
how that judgment is applicable to this case? Trial court has not made any discussion.
No, that discussion in detail is not there, but then plaintiff's case, defendant's case has been projected. And then, my lord, after going through the above judgment and the material available on record, it can be concluded the plaintiff is in the bona fide requirement of the suit premises accordingly. And the judgment that the landlord is the best judge that has been quoted.
Okay.
My lord, the only argument against this is there are other shops, and this is the judgment which is normally referred in a case set up by the tenant, that there are other tenants, why are you not choosing them? Then the Supreme Court has said he is the best judge to whom to
Which-
evict first.
Okay.
Yes, madam. Your lordship is aware of that. And this has been affirmed by the first appellate court, and which your lordship will find. Let go there. There are 140 onwards, please. Page 125. Page 127, or should you kindly see? Page 127, para 148. The respondent number 2, SPW2, had deposed in his evidence in affidavit,
No, page one.
page 127, madam. Para 148.
Yes.
The respondent number 2, SPW2, had deposed in his evidence in affidavit that he is a doctor by profession, and after the death of his father, Vibha Basu Chaudhary, original plaintiff, he was compelled to shift to Silchar and leave his job at Kolkata to look after his mother and also to protect the interest of Elora nursing home belonging to his father, late so and so. Respondent number 2, SPW2, had further deposed that the inherited Elora nursing home from his father, late Vibha Basu Chaudhary, along with his mother, and he is presently looking after the affairs of the Elora nursing home, and he requires the suite premises for the development and renovation of Elora nursing home. Although cross-examined, the learned counsel for the appellant defendant could not impeach his veracity or credibility and make his evidence doubtful. The appellant had admitted in his cross-examination in so and so that the suite premises is situated adjacent to the entrance gate of Elora nursing home. And in the entrance gate, he is there, and because of this, when this is my learned friend's instruction, when the ambulance comes, he creates obstruction matter, and that is why the eviction is necessary. It appears from the evidence on record that Elora nursing home was established about 34 years back, and a structure which is so old obviously needs renovation and expansion with the efflux of time. Further, respondent number 2, SPW1, had not taken the plea that he wants to stay in the suite premises after evicting the appellant, but his plea is that he intends to renovate and expand it. The requirement of respondent number 2 appears to be cogent because the suite premises is situated adjacent to the entrance gate of Elora nursing home, and the same appears to be creating hurdle in the ingress and egress of the ambulance. This is there, ambulance and other vehicles to the Elora nursing home, and destroying the suite premises would provide easier access to the patients, ambulance, etc. In Pratibha Devi again quoted, my lord. Then Sarala Ahuja is also quoted. It is not for the tenant to dictate the term to the landlord as to how else he can adjust himself without taking possession of the tenanted premises. While deciding the question of bona fide requirement of the landlord, it is quite unnecessary to make an endeavor to see as to how else the landlord could have adjusted himself. Then para 159, my lord, at page 130. As the evidence suggests that the respondent number 2 requires the suite premises for extension, development, and improvement of business of Elora nursing home, I am of the considered view that his requirement is bona fide, and the appellant cannot take the plea that the respondent number 2's requirement is not bona fide only because later has several other properties. All these discussions are there, my lord, in the first appellate court judgment.
Okay.
And that is my submission. That's a clear case which is, my lord, concluded by finding of fact recorded by the courts below. The revision petition may be rejected, my lord.
You are submitting any judgments? Or
My lord, regarding written statement, my lord, if there is a denial, my lord, with respect to that, with a copy to the other side, I will, by today itself, I will.
okay.
That
Heard
only
this.
denial is sufficient. And
Yes,
for
that is the
that,
main issue in this case.
and I will have to prove by way of evidence. That judgment I will prove.
Okay. Heard Mr. S. K. Ghosh, learned counsel for the petitioner. Also heard Mr. D. Majumdar, learned senior counsel assisted by Mr.
G.R. Datta.
G.R. Datta, learned counsel for the respondent. Hearing concluded, judgment reserved.
My lord, regarding this submission that he is doing a judgment regarding the denial in the written statement. My lord, denial was in respect of an averment in the plane with regard to
Deposit.
offer and deposit, but refusal, there was no statement in the place, so there was no denial of refusal. Whereas under the law, there is a requirement of refusal also by the landlord before deposit.
So unless he pleads
Yes.
specifically in his written.
There was
statement that
refusal.
There was
Refusal,
offer, refusal
my
and
lord,
denial.
my lord, my lord.
He cannot plead evidence regarding refusal.
The Daftari judgment is very clear, my lord. It has been referred.
Okay.
Much deeply open.
I'm taking.
My
This case is wrongly listed in orders column as this suit, as this RSA is ready for hearing. List this matter after 4 weeks on a date to be fixed by registry
Bless.
for hearing.
May I please lordship. My lord, file this case, my lord, against the. My lord, I file on my lord, amended cross title, my lord. Because MFA 11/24, it would be my lord,
Why this I is for what purpose?
my lord, staying the into judgment and order. My lord, I have put it, my lord, substantial question of law. 4, 5, and 6. Because it is not a permanent, it is a temporary.
Whether notices are issued?
No, this is the first time, my lord.
No, but this MFA was filed in February.
Yes, my lord, it is what has happened, my lord. There is some mistake on my part. With the numbers, my lord, claimant, it is respondent number 1, become the same person. Then I amended this case by various order and filed in my lord cross title.
No. Understand. There are many IAs.
There is no I, only one I, my lord.
This IA 421, it is for what purpose? IA 421, Asene dispose of.
For delay, my lord. Yeah, but the staying the,
IA 421 is for condonation of delay.
yes.
So RSA is, then how orders are passed in RSA court?
My lord, not RSA.
No, sorry, MFA.
MFA. But
Saying condoning the delay in filing the first appeal.
my lord, MFA,
Delay has not been condoned.
there is no.
Hmm?
There is no delay, my lord.
No, you know whether there is, I am just asking
There is
for,
no delay, my lord. It is in time.
then
Only this is the, my lord, IA is for one.
there are two IAs. IA 421 and IA 458.
my lord, I have to check this one.
Just a minute, let me see. Order 41 Rule 5 for stay,
My lord, another I is 458.
and 458 is for?
It is another case, my lord. It is second case. It is in connection with the MFA 12/24. That is,
12 to Belekere.
yes, there is no delay, my lord. There is a IF for Molly staying the operation of the Lincoln judgment and because I think it is I might tell you this that, my lord.
We are issuing notice,
Yes, my lord.
with issuing notice in
If you notice, my lord, it is appeal. Because it is a.
this, in appeal. MFA 11,
Yes, my lord.
item number 8, item number 8 on MFA 11 of Liverpool. Heard Mr. R.C. Paul, learned counsel for the appellants. This you have corrected the name of respondent number 1.
Yes, I corrected by filing the amended
Amended.
post title.
This appeal under section 30 of the Employees Compensation Act 1923 has been filed by the appellant insurance company impugning the judgment and order dated 21/12/2022 passed by learned commissioner, employees compensation Nagaon in NEC within bracket WC bracket close case number 60/2013, whereby it awarded an amount of rupees 5,20,548 to be paid to the claimant respondent number 1 by the appellant with an interest of 9% per annum from the date of accident till realization. The appeal is admitted. Issue call for the case record of NEC within bracket WC case number 60/2013.
Now it is 60, WC case number 52%. WC case number, my lord,
60.
61.
It is 60 in MFA 11. It is 60. If it is 61, you have to amend your
MFA 60,
MFA number 11.
11,
The trial court records is 60.
60.
That you have mentioned in your memo of appeal. From the
My lord, I have to go through the record. My lord, give me the 1 week's time for something. I think some mistake is going on there. So my lord, kindly give me 1 week's time. So I have written some mistake. It will be 162, 51 possible. Because there is a 2 WC case.
cut off.
That is all right.
Heard Mr. R.C. Paul, learned counsel for the appellant, who prays for 1 week time
My lord.
to make some corrections which might have crept in the memo of appeal due to inadvertence. The prayer is allowed. Let this case be listed again after 1 week
My lord, both
on a
the
date to be fixed by registry, both the cases.
cases, because there is some mistake. Much obliged.
May I please, your lordship? Lordship, pursuant to your lordship's order dated 2/8/24, the affidavit which I had filed with regard to service of justice has been tagged along with the case record. Your lordship. On the last occasion, it was not there. So this justice service has been done by me pursuant to the order dated 26/6/24.
How many respondents are there?
The main respondents have been taken. There are total, the brothers have been served, your lordship. Respondent number 1, 2, 3, and 4. And the affidavit which I have filed in support of it through the petitioner herself. It is stated in para 3 that the justice was served on 12/7/24, your lordship, which is within the time that was granted by this honorable court.
No, you have taken steps as regards which of the respondents?
Respondent number 1, 2, 3, and 4, your lordship.
Respondent number 1, 2, 3, and 4.
That is as per the direction of this honorable court, your lordship. Because on the
And
last occasion, the
as
office
regards
note says
other-
that
Other respondents,
the other respondents are ex parte, your lordship, because number 5, she has refused from the last office note, it is there.
so
And,
whether,
the others are pro forma. So their
so,
presence are not required, your lordship.
no, then you will not, if you make them parties, then you have to issue notice.
No, we have issued notice on the last occasion. They have not turned up. The office
No,
note is there.
whether notice has been served or not.
It has been served. It appears it has been given in the last occasion. It was there.
But there is no order to the effect that of
There is
due-
no order to that effect, but only this honorable court on the last occasion on 26/6. They only specifically directed with regard to the.
It has
main
not
defect.
waived the notices on the other respondents. It has only
Their
direct,
name may be struck off, your lordship, because in the main trial court also, they have not contested the matter, your lordship.
which respondents you want to?
Respondents number, the pro forma, all the pro forma from respondent number 6 to 18, your lordship. The other main respondents have already been served. Number 5, who is my sister, she has refused. It is there on record in the office note.
Mr.
A. Biswas.
A. Bishwas, learned counsel for the petitioner. He submits that in pursuant to the direction of this court by order dated 26/6/2024, the petitioner has taken steps, petitioner has effected the service of notice on respondent number 1 to 4 by Dusty Mode and has also filed an affidavit of compliance to that effect. Stop. On perusal of the affidavit filed by the petitioner, it appears, which is accompanied by a copy of notice to the respondents wherein the signatures of respondent number 1, 2, 3, and 4 are appended. Stop. It appears that the notices are duly served. Hence, it is held that the notices issued to respondent number 1 to 4 are duly served. As regards respondent number 5 is concerned, where is the
Office note was there, your lordship, in the where she has refused the.
respondent number 5 is concerned, it appears from office note dated 29/5/2024 that the notices sent to respondent number 5 by registered post with AD have been refused by, have returned back with an endorsement on the envelope within inverted comma, refused, stop, capital RTS, inverted comma, close. Why you did not took step for respondent number 5?
5, it was because already she has refused the.
No, but there was no such directions.
The court had
The
said that
court said that on 26/6/2020.
a refusal is there, your lordship. So the court had said with regard to the brothers, this with regard to the only other 4 persons, your lordship,
No,
because the refusal is already on record. The others, the ID card had not turned up. So because of that,
no,
We
but
have taken
court
step.
directed, court did not segregated that respondent number 5.
it was not specifically, but a refusal is there, so it is deemed, your lordship, with regard to that, because the
No, unless
service
there
was
is an order of the court.
the order of the
cannot-
court is not there. But we had taken only with regard to 1, 2, and 4. 1, 2, 3, and 4, your lordship.
Why you choose not to issue notice to respondent number 5 when there was no such specific direction? by
But
the-
now I can make a submission because the refusal is there, deemed service can be taken, your lordship. Because the others, the ID card did not turn up. Here, 5, a refusal is there on the office note, your lordship. So under order 5, it is there that a refusal is there. She refused it, so
Where does she stays? Your sister, where she stays?
pardon, your lordship.
Where your sister stays?
On the same location where the other brothers, in the same. We are staying together in the same residence. Your lordship will see the first title where the. In the same place, your lord. Five,
Stop.
6
In-
of us.
In view of the refusal to accept notice by the respondent number 5, the notice.
Same premises.
Notice is deemed to be duly served on her also. Stop. Learned counsel for the petitioner has also submitted that as the presence of pro forma respondent numbers 6 to 18 may not be necessary for consideration of this civil revision, their name may be struck off from the revision petition. Stop. Considering the submissions made by learned counsel, the prayer is allowed. The names of this pro forma respondent number 6 to 18 may be strike out from the revision petition, the registry to do the needful. Let this case be listed for admission hearing. After
Any date, your lordship, because it is for an amendment of a.
after 1 week,
After
after 1 week, on a date to be fixed by registry.
Obliged.
May I please your lordship? My senior is on leg due to water lagging. My lord.
What is your prayer?
The matter may be passed out, but for time being. He's on the way, my lord. In his area, the Sadgaon area, the whole route. Water.
He's in legs where? In court or in water?
He's
In water.
stuck in the traffic, my lord. Presently stuck in the traffic.
So, my lord, matter
The road
for the
the road
day.
is blocked, my lord. So on the other way, he's stuck.
No, what is your prayer?
Passover for
For the
time being,
time being.
time being.
My lord, it is Sadgaon, my lord.
No, my lord, he is presently, I think, Guwahati Club or he's on the way. My lord.
We have to use.
After 15 or
GPS.
20 minutes, he will be present.
Okay, we'll pass it over for the time being.
Oblige, sir.
After some, wait for something.
My lord.
Highly obliged.
Wait for half an hour.
Half an hour, my lord.
Item numbers. Yes.
My lord. Let me lord. But item 12, my lord, it was heard at length, my lord, on 21st of May. And the all court, my lord, it was fixed for further hearing. So, my lord, it is deemed to be part heard as per consequently see order 21, my lord. Additional substantial question of law was also framed and case fixed for further hearing on 20th of May. But it was not listed. Bench was not.
Heard, my lord.
No,
It's part heard.
Not part
language, my lord, further hearing means, my lord,
It
pardon.
is not part heard.
It was heard at
My lord.
length, my lord. Paragraph 3, my lord, in the order.
What to do?
My lord, my submission is that matter will be heard and it may be disposed of, my lord. My lord,
No, if it is part heard.
well, it is not
my lord.
part heard. Where is the word part heard is mentioned?
So a substantial question of law has to be framed. Whether further hearing means part heard.
Yes, my lord. Further hearing means, my lord,
Hmm.
further hearing, my lord,
There is
normally
no word, my lord.
by same
part-
court, my lord.
Part heard is
Otherwise,
mentioned, my lord.
case is fixed for hearing.
They wants to. my
Further
lord,
hearing, my lord,
It is-
continuation of the hearing.
No, but court has not specifically
Yes, my
mentioned
lord.
it to
No
be part heard.
specific mention as a part. What is the problem to doing this case?
Are you ready?
Not today, my lord, because, my lord, file is, my lord,
Then-
locked under, my
Then
lord,
make that.
water
submission.
logging. No,
They should
because, my
make
lord,
that submission.
interpretation, my lord, of the order, my lord, further hearing, my lord, normally, my lord, by same court.
No, you are not ready. If you make that submission, I am.
My lord,
Adjourning.
our part may
It
be
may
taken up,
taken-
my lord. Our part may be taken,
It
No.
may be taken next week.
Let him come prepared.
my lord.
Heard Mr. R. Ali, learned counsel for the appellants, also heard Mr. A. R. Sikdar, learned counsel appearing for the respondents. Learned counsel for the appellant has prayed for an adjournment on the ground that he has not brought the file.
Because of
Whether-
confinement by water, my lord.
Whether the file has been washed, my lord. washed or-
I will not wash. You can, yesterday I have
Due to personal difficulty.
5 hours
My
to
lord-
go home, my lord.
My lord, day after tomorrow may be taken up.
Let this matter be listed after a week on a date to be fixed by registry. After a week.
My lord, our here is, my lord, the matter be taken up in the next day of hearing within this week, my lord.
No, next week. Let us see the roster next week.
Wash.
Next week on a date to be fixed by registry.
Deeply.
May I please, your lordship? Lordship, I am making this prayer on behalf of Mrs. S. Roy, your lordship. Due to some cardiac problem, your lordship, she is being hospitalized. I pray
She is
for.
the engaged counsel.
Yes, your lordship.
Heard Miss
F. N. Jaman on.
F. N. Zaman, learned counsel, appearing on behalf of Mrs. S. Roy, submits that. No, not submit, prays for an adjournment on the ground that the conducting counsel, Miss S. Roy, is having some health issues.
Yes. Sir. Yes, hospitalized.
Considering the submissions made by learned counsel, the hearing is adjourned for today. The registry to list this matter after a week on a date to be fixed by registry.
Oblige, your lordship.
But I am for the respondent. my lord.
Appellant is not there.
Let us wait for some,
Okay,
let us see, my lord, if this matter gets over, my
okay.
matter of 14, my lord.
After some time.
After some time, let us.
It is the lordship. This can appeal is directed against the order dated 27/6/2023. It starts from page 35, my lord, whereby the appellate court, my lord, although agreed with the issue number 3 as held by the trial court in favor of the plaintiff, but at the end, my lord, the appeal was allowed, meaning thereby my suit was dismissed. I'll take your lordship, my lord, I'll just.
No,
please-
what happened in the trial court? Suit was decreed.
Suit was decreed in the favor of my lord appellant plaintiff.
What was the suit?
Suit was for recovery of money, my lord, for a work
It
undertaken.
was
by-
a money suit.
Money suit, my lord.
Okay. Thereafter,
Yes, my lord. The trial court, my lord, decreed the suit in part. Trial court, lordship had kindly. I'll take a lordship, the order, my lord, on page 20 is the type copy of the trial court judgment, my lord. Based on the pleadings, my lord, issues were framed, and issue number 3 dealt by the trial court found that the plaintiff is entitled for labor payment of rupees 1 lakh. Lordship, page number 20 has got lordship.
yes.
Yes. In the bottom, my order, it is written there. In result, the suit is partly decreed on contest. The plaintiff is entitled to get cost as mentioned in Exhibit 5 series, that is rupees 1,92,740. Thereafter, next paragraph. It is observed that the defendant number 4 admitted the liability of the plaintiff for the claim made by him, except labor payment, which is also very clear from Exhibit 4 series. Thus, foul play on the part of defendant number 4 leading to this litigation cannot be ruled out. Thus, equity, justice, and good conscience demands that plaintiff is entitled to get balance amount except the decreed amount from the defendant number 4. So, my lord, suit was decreed in favor of the plaintiff, 1,92,740.
No, this is the judgment of the trial court.
Yes, ma'am.
And how it is saying that decretal amount?
Pardon?
What it means when it says except decretal amount?
Except the quote. The decree page we have tried, minus page 22. Page 22 is the decree page, my lord. And second paragraph, lordship will find. Lordship has got it.
Hmm.
Yes. In this case, my lord, may trace the facts, my lord, from the plaintiff. In this case, my lord, the plaintiff filed this suit as he was entrusted to undertake some renovation work of a hospital, man. Renovation of some gate, painting, and etc., my lord, by the defendant number 4, who was then the chairman of the committee, my lord, hospital management committee. Paragraph 3, page 6 from the plaintiff, if I may read, large read, my lord. Page 6, paragraph 3, my lord.
Yes.
That the Nilambajar PHC Development Committee, which expression he is here and referred to as committee, entrusted the plaintiff to perform all the construction and development works, that is construction of front gate, repairing, painting, and other maintenance, and construction works of seat PHC wide letter dated 4/12/2007, that is Exhibit 1, madam, issued by defendant number 4, the then chairman of the Nilambajar PHC. The defendant number 4 wide his aforesaid letter instructed the plaintiff to perform the said work as per direction of the development committee with effect from 9/12/2007, and to realize the expenses from defendant number 5 on submitting bills from time to time. In the said letter, it was clearly mentioned that committee will demand further works after clearing the entire bills. That as per paragraph 4 of the plaintiff, madam, I'm reading, that as per direction of the committee, the plaintiff performed construction of front gate, repairing, painting and other maintenance and construction works of Neelam Bazar PHC with the satisfaction of the committee. And as such, he submitted bills from time to time, total amount of rupees 6,05,885 only, consisting cost of raw materials, labor payment, conveyance, etc. to the defendant number 5, cashier of the committee. The defendant number 5 duly received the said bills. He also paid an amount of rupees 5 lakhs only to the plaintiff time to time and promised to clear up the remaining dues on receipt of further funds allowed from the last payment. That subsequently committee was reconstituted as per newly, that is not my relevant, 7 is very relevant, color. That the committee in its meeting held on 1/11/2008 passed resolution to clear up the outstanding dues incurred for the effort. On 3/8/2009, the plaintiff learned that defendant number 42325 in conjunction with other members of the committee entrusted further construction and development works of the Neelam Bazar PHC to person except the plaintiff and complete the said works without making payment of the area due to the plaintiff. The plaintiff spent his own money and performed the appropriate works relying on the letter issued by the defendant number 4. So plaintiff having alternative has taken shelter of this honorable court for redress of relief that the defendant should be restrained by an order of ad interim injunction and perpetual injunction from illegal acts and deeds and from entrusting any further construction for repairing works of any kind of Neelam Bazar PHC until clearing the balance amount of rupees 4,05,885 to the plaintiff. Otherwise, the plaintiff shall suffer irreparable loss. Now, at the prayer part, that the plaintiff prays for decree for a declaration that plaintiff is entitled to realize the outstanding bill amount of rupees 4,05,885 only with interest at 12% from defendant number 5. So that is the main prayer of the plaintiff for clearing up his dues matter. So in this case, the defendant number 4, the file is WS, that is at page 10 matter.
Only defendant number 4 contested.
No, madam. Other defendant also contested, madam. Their WS in page 13. I'll go to that, madam. Firstly, madam, reading that WS of the defendant number 4, who has admitted, madam. May I read page 11, madam, paragraph 9 of the WS file with the defendant number 4, the chairman of that committee, madam.
Yes.
The salient text of the case is under A, that the defendant number 4, as the chairman of the Neelam Bazar PHC Development Committee, for and on behalf of the said committee, entrusted plaintiff to perform all the construction and development works, that is construction of front gate, repairing, painting and other maintenance and construction works, and instructed the plaintiff to perform the said works as per direction of the development committee with effect from 9/12/2007 and to realize the expense from the defendant number 5 on submitting bills from time to time. It is fact that assurance was given to plaintiff that he would be entrusted with further works of the PHC after clearing bills for the phase. The answering defendant, as per instruction of the Neelam Bazar PHC Development Committee, issued letter by dated 4/12/2007 to this effect. So that is exhibit 1, madam, to which I was directed to perform these works. Number B. That accordingly the plaintiff performed construction of front gate, repairing, painting and other maintenance and construction works of the Neelam Bazar PHC with the satisfaction of the committee and submitted bills from time to time. The plaintiff submitted bills of rupees 6,05,885 only to the defendant number 5, out of which an amount of rupees 2 lakh only was paid to him due to insufficiency of fund, and the committee promised to clear up the dues on receipt of further funds, and in this effect answering defendant issued a liability certificate in favor of the plaintiff as per instruction of the committee. The answering defendant number 4 left the chairmanship with the reconstruction of the committee. In his place, defendant number 3 was nominated. So, madam, he also issued a liability certificate, which we have exhibited as exhibit 2, madam.
To the extent of how much?
That, madam, 4,05,885, madam.
Okay.
Thereafter,
Yes, that Nilam Bazar PHC Development Committee taken resolution to clear up the dues to the plaintiff in its meeting dated 1/11/2008, immediately on receipt of further fund. That resolution we have also Malad exhibited as Exhibit 3, whereby that was resolved that plaintiff will be entitled to get Malad his payment on receipt of further funds. So Malad, thereafter the defendant number 1, 2, defendant number 5 Malad submitted WS, filed his WS on behalf of other defendants, denying this claim of the plaintiff, and Malad page 14 lordship may kindly peruse. May I read, Malad?
E 1 to 5.
Yes, 1 to 5, Malad. One, he filed, Malad, except 4, his WS was filed by
Other dependents.
but from the records, we do not find in the affidavit that he has filed on behalf of authorized by other defendants. That is, that affidavit page, we do not find by anything. That he is authorized by the other defendants to file this WS. We have also brought this on record by cross-examining him. That
Okay.
the plaintiff has no entitlement to realize the amount claimed in the plaint, no question of accused interest thereof. There is no PHC development committee, rather a hospital management committee exists. The hospital management committee did not entrust anybody for any construction and nor development work as claimed by plaintiff. The defendant number 5 has no knowledge of the letter dated 4/12/2007 issued by the defendant number 4, and there is no existence of any such letter in the PHC record. The hospital management committee did not direct anyone to perform any construction or repairing works, and hence no question of receiving any bills arises. The defendant number 5 did not receive any bill from the petitioner. Further, defendant number 5 is not the cashier of the committee. That no bill had been received by defendant number 5, nor any payment made to the plaintiff. That the committee was reconstituted as per, I'll skip that paragraph and go to the next paragraph. That the works mentioned in the resolution of the meeting dated 1/11/2008 of the hospital management committee was done by the hospital management committee, and the plaintiff was engaged to supply laborers and supervise the works. So here, my lord, he has admitted that plaintiff, that is the present appellant, was engaged, my lord, for supply of laborers and to supervise the work.
Okay.
He was asked to submit bills as per state government norms with master roll and attendance, but the bill was not submitted in due time, for which the payment could not be made. Further, for information, till date, no bill has been received. Moreover, the amount claimed by the plaintiff is absurd as labor cost. Number, I'll show from the cross-examination, my lord, he has submitted that he has not supplied any master roll or other documents for submission of bill for the labor payment, my lord. As stated by the petitioner, the hospital management committee nor the defendant number 5 in collusion with any member entrusted any construction or development works of the PHC to any personal agency. The quarter repairing works going on the PHC is being done by the departmental agency, that is they are married the record, that as the defendant number 5 had not entered into any terms and conditions in any form under the form with the plaintiff, hence the question of violation of terms and conditions arises. Under this, the suit is liable to be rejected. So, based on the pleadings of both the parties, the learned trial court issued framed as many as 5 issues, my lord. Page 18. Page 18 is the operative part, my lord. Lordship has got it.
Yes.
Yes, my lord. Issue number 3, my lord. Whether the defendants have received construction work towards an amount of rupees 6,05,885 at the cost of plaintiff. So this issue was first taken, my lord. May I read, my lord?
Yes.
This being the most vital issue is taken first for discussion. It appears that the whole dispute between the plaintiff and the defendant
What evidence was led?
by plaintiff, my lord.
Plaintiff.
Yes, my lord, I have exhibited the
How many witnesses were examined?
2 examined, my lord, including the plaintiff as PW1.
And defendant side?
Defendant side only, my lord, DW1, defendant number 5 has examined himself as DW1, and no two documents, my lord, were exhibited by him, which were under objection, my lord. He raised objection during marking of the 3 documents, my lord. And we have examined, my lord, as many as 5 documents from exhibit 1 to 5 to prove our case.
Okay. There are.
This being the most vital issue is taken first for discussion. it appears that the whole dispute between the plaintiff and the defendant number 1, 2, 3, and 5 and 6 revolves around this issue. Careful scrutiny of the averments in the plaint and plea raised by the said set of defendants, it appears that there is no dispute between them with regard to the fact that as per decision of management committee of Nilambajar PHC, the plaintiff was entrusted to supply laborers for construction and repairing works of Nilambajar PHC. The defendants have disputed that the plaintiff was not entrusted in any way by the hospital management committee to perform works of construction and repairing, etc. Therefore, it is bounden duty of the plaintiff to prove that he was entrusted to perform the works as pleased by him. It is pertinent to mention that plaintiff side has not examined defendant number 4, who submitted WS, admitted the case of the plaintiff. Plaintiff Joinul Haq has submitted examination in chief by way of evidence with affidavit stating the same fact as about in the plaint. On behalf of defendant number 4, cross-examination of PW1 was declined. However, learned GP cross-examined PW1 on behalf of other set of defendants. The PW1 has admitted that Exhibit 1, the copy of work order issued by Siddiq Ahmad MLA, South Karimganj constituency, does not reflect any terms and condition, and no consideration amount for the contract amount also mentioned. He also admitted that after issuance of Exhibit 1, no specific order was issued to him for construction of front gate, repairing, etc. That was in Exhibit 1. It was clearly stated that he has to start the work from 9/12/2027. He has also admitted that Mr. M. Dev, defendant number 5, has not issued any work completion certificate in his favor. PW1 also stated that the vouchers of expenditures as regards completion of work which he submitted are available in the office, but he has not called for the same. PW2 Sirajuddin, who is a mason by profession, stated that PW1 engaged him in the construction and repairing work of Nilambajar PHC during the year 2007 and 2008. He has deposed that in the said work, he engaged other mason laborers as per instruction of PW1. PW3 did perhaps PW2, PW3 has proved Exhibit 5 series being wage payment sheet. In cross, PW2 has stated that he was not engaged by the government in the said work. He has also stated that work was for construction of hospital. Exhibit A being notification come order by the Governor of Assam dated 6/11/2007, Health and Family Welfare Department of Assam, the circle officer or the concerned PHC was made chairman of Hospital Management Committee of Block PHC in the state, and the order came into immediate effect. That being the position, Exhibit 2 liability certificate issued by the defendant number 2 has no force in the eye of law. It's not there, my lord, because on the date of issuance of Exhibit 2, the defendant number 4 did not have any locus stand to issue such certificate in capacity of chairman on behalf of the Nilambajar Hospital Management Committee in view of the notification by Exhibit A, defendant number Exhibit A. Defendant number 5 and Dev DW1 in his evidence categorically stated that the Hospital Management Committee of Nilambajar PHC did not entrust PW1 for construction and other development works, including construction of front gate, repairing, etc., and to realize the expenditure from him, submitting bills from time to time. He also denied that he ever made payment of rupees 2 lakhs to PW1 and also denied any promise to him to clear up the remaining dues. He has deposed that as per meeting dated 4/12/2007 of the Hospital Management Committee, as per request of Siddiq Ahmad MLA South Karimganj constituency, PW1 was engaged only for supplying of laborers and to look after the works. The supply of laborers and supervisor of work is admitted by both the sets of defendants. He also stated that PW1 failed to submit the master roll regarding the labor payment made by him to his office. In cross-examination, he has categorically denied the issuance of any work order to the plaintiff. It is not our case, my lord, that Mr. Defendant number 5 has issued the work order. It is the defendant number 4, my lord, by the Exhibit 1 that order was issued. He has also reiterated that PW1 simply supplied laborers by his verbal order. So, my lord, it is defendant number 5 stated that is on verbal order, my lord, that defendant number supplied the laborers and supervised the work. He also submitted that PW1 has not been paid any amount against wages of laborers supplied. He has admitted that front gate of hospital was repaired and repairing work was already done. Thus, from the evidence of DW1, it is clear that subsequent to exhibit number 1, no formal order was given to PW1. It appears from the evidence of both sides, as discussed above, that whole case of PW1 rests on oral contract with him in one hand and Hospital Management Committee of Nizambajar PHC on the other hand. Although DW1 has admitted that front gate of hospital and repairing work has been done, but he has not admitted that the said work was done by the PW1. DW1 also neither admitted in his clause that he has undertaken the work. It appears that original of Exhibit 4 series being received by defendant number 4 of this said case, Siddiq Ahmed defendant Siddiq Ahmed MLA. However, there is no date of defendant number 4 below his signature. On the other hand, plaintiff side has not called for original Exhibit 5 from defendant side. Exhibit 1 does not speak about consideration amount of the contract for which the contract was given to PW1. It has already been held that Exhibit 2 is not a valid document in the eye of law. As such, same cannot repair the case of the plaintiff on consideration of the evidence on record, and for reasons cited above, it can be safely concluded the plaintiff has failed to prove that he was entrusted with the construction repairing work for an amount of rupees 6,05,885, and it appears that the plaintiff is entitled to get only cost of wages which he has paid to his engaged laborers in the works of said PHC. Issue is answered accordingly, madam. So, my lord, on careful perusal of the evidence, the trial court, my lord, held this issue in affirmative in favor of the plaintiff only to the cost of laborers, my lord. The issue number 4 was, my lord, whether the plaintiff is entitled to get a decree for realization of 4 lakh. In view of the finding arrived at a vital issue number 3, plaintiff having failed to prove the fact that he was engaged for contract work of consideration amount of rupees 6,05,885, he is not entitled to get rupees 4,05,885. Be it mentioned that PW1 simply stated that he received rupees 2 lakh on the other hand, 2 lakhs. On the other hand, DW1 has denied making of such amount to the plaintiff. On the other hand, plaintiff has failed to submit scrap of paper to show that he received rupees 2 lakhs from defendant number 1. Issue is answered in negative and against the plaintiff. And my lord, that issue number 1 and 2 was related to the maintainability of suit and cause of action, my lord, that was held in favor of the plaintiff. My lord, and accordingly, my lord, the suit was
No, as regards issue number 3,
my lord.
when it was held that plaintiff is entitled to get the cost of wages.
Yes.
What was the cost? How much he?
That is, my lord, reflected in last part order, my lord, under the order part, my lord. Page 820 below, my lord.
Exhibit 5 series.
Exhibit 5 series. 1,92,000.
But in the issue, it is not mentioned.
It is not mentioned, my lord.
Okay.
It was not clearly mentioned, my lord. So, my lord, the suit was partly decreed. The decreed amount was 1,92,740. And my lord, since the defendant number 4 in his WS, my lord, he has admitted that what was
Decreed against who? Which of the defendant was directed to?
when the prayer was made, the specific relief claimed against my lord, defendant number 5. If lordship peruses our prayer portion, which is at page 8, my lord.
No, but the order was against defendant number 4. Defendant number 4 was directed to pay that labor payment charges.
1,92,000, my understanding is against other defendants, my lord, and the rest amounts are to be paid by the defendant number 4. It is
Rest amount, which rest amount?
that 2,13,000, my lord.
2,13,000?
2,13,115.
How, where it is mentioned?
It is not mentioned. We have our claim, my lord. Our prayer was to get rupees 4,08,000, 4,05,885, out of which, my lord, the trial court decreed the suit to an amount of rupees 1 lakh.
You are, as far as I understand.
Yes, my lord.
From the reading of the order. only defendant number 4 was directed to pay 1,92,740.
Lots,
Only that much,
lots,
nothing else.
nothing else.
Or is it otherwise?
My lord, page
You may explain it to me if it is otherwise.
Because, my lord, the trial court held that exhibit 5 series, the plaintiff, as admittedly the plaintiff has supplied laborers and he supervised the work. So he entitled to get the wages paid to the laborers in exhibit 5 series. Now, my lord, it has been admitted by the defendant number 5 that on his verbal instruction and as per the resolution, plaintiff has supplied the laborers. So, my lord, in my humble understanding, that 1,92,000 decretal amount are to be paid by the other defendants, my lord. And the rest amount, that is 4 lakh, rest, my lord, 4,05,885 minus
No,
1 lakh,
there is no such finding regarding
Yes.
the rest amount. Where is the finding?
which is not there, my lord. So, my lord, we,
So trial court only directed defendant number 4 to pay 192,740. Entitled to get balance amount except in the decreted amount. What it means, last line of para 20,
page 22,
page
my lord,
20.
page 20. The dignity justice it is observed that the defendant number 4 admitted the liability of the plaintiff for the claim made by him except labor payment, which is also very clear from exhibit 4 series. Thus, foul play on the part of defendant number 4 leading to this litigation cannot be ruled out. Thus, equity, justice, and good conscience demands that plaintiff is entitled to get balanced amount except the decretal amount from defendant number 4. So, decretal amount, my lord, my
Is
understanding,
this get the balance amount except the decretal amount? What is the meaning of this?
my lord, we supplied at the time of my lord admission, we another set of my lord substantial questions. Plus, we will find it is on record, my lord.
What
Where-
substantial question of law was framed? Formulated.
My lord, we find a substantial question which we filed with the memo of appeal. Page 3, my lord.
Then the defendant number 4 is having accepted the liability. What appellate court did?
My lord, appeal. It starts from page 35, my lord. And appellate court, my lord,
This last line is not clear.
the trial court order, my lord.
Trial court's orders.
So against that, my lord, the defendant number 5 preferred an appeal, my lord, title appeal, money appeal against the present plaintiff, and the defendant number 4 was also made a party respondent, but he did not contested the appeal. And if I may take a lordship to page 38, my lord, that is the operative portion where issue number 3, my lord, 39, page 39, my lord.
Page
39, my lord, of the appellate court's order, memo of appeal, my lord. 39. Trial court also took up this issue, my lord. May I read, my lord?
yes.
The learned court below firstly took the material issue number 3 for discussion, and while so discussing mainly observed that exhibit 1 does not speak about consideration amount of the contract for which the contract was given to the plaintiff. Learned court below held that exhibit 2 is not valid document in the eye of law, unable to repair the case of the plaintiff, and concluded that the plaintiff failed to prove that he was entrusted with the construction of repairing works etc. for an amount of rupees 6,05,885. On the contrary, it appeared to the learned court below that the plaintiff was entitled to get only the cost of wages and decided the issue. After hearing both sides, perusal of the evidence on record, it reveals that the issue number 3 has rightly been decided and thus needs no interference. So that was the issue, my lord, based on which suit was decreed partly. Now, my lord, 4 and issue number 1. Issue number 4. The learned trial court decided this issue in negative, holding that the plaintiff is not entitled to get an amount of rupees. That issue, my lord, as was upheld, my lord, as by the trial court. Trial court also held that I am not entitled to 4,05,885. That was also upheld by the appellate court, my lord. Now, issue number 1, my lord, cause of action. Cause of action. May I read, my lord?
Continue after.
There is a part-heard matter in the supplementary list. Your lordship had fixed it for today. Supplementary item 33.
R.D. Majumdar is.
Yes, my lord.
Lordship, my senior is suffering from toothache, lordship, so he had to court, will meet the court with it.
Okay, when do you want to?
Next Tuesday, 13th.
13 we have. Okay, it is part of it.
Yes.
Heard Mr.
SP Sharma, lordship.
S.P. Sharma. Also heard Mr. S. Dr. Leonard, Senior Counsel. Mr. S.P. Sharma submits that prays for an adjournment on the ground that the conducting counsel is R.D. Majumdar is indisposed. Leonard, Senior Counsel for the appellant.
No, for the respondent.
For the respondent. Does not opposes the prayer. The prayer is thus allowed. Let this matter be listed again on 13th of August.
Deeply obliged.
This IA has been disposed of, which is, it is shown in the cause list. But it has been disposed of on the last.
Obliged, my lord.
May please your lordship, item number 29, lordship. This matter may kindly be taken up next week, lordship.
Why?
Lordship, it's about to rain again, lordship, due to waterlogging yesterday.
Heard, Miss, what is your name?
P. Sharma, lordship.
Heard, you have informed the council.
Lordship, he is present.
Heard Miss P. Sharma, learned counsel for the respondent who prays for an adjournment on the ground of personal difficulties. Learned counsel for the appellant does not opposes the prayer, hence the prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Lordship.
There is an interim order.
The interim order shall continue till next day. Yes.
My please, lordship. Also, item number 26. That is a matter between landlord and tenant. Revision proceeding under 115 of CPC, lordship. Lordship, I am representing respondent side who is 70 years of age.
No,
And-
what is your prayer?
My prayer only to upgrade the matter, lordship.
No, there is no time left for upgradation. Because at 2 we are having a VC fix. And then a matter is going on part heard.
If time permits, as a last item, lordship.
No, it may be difficult because others are, you try your luck. Wait,
In the midst of hearing.
we'll take it after that.
Yes, because one problem is I requested my learned friend. I have to leave to Arunachal Pradesh also. That's the whole problem, my lord.
Okay.
But there is some
The matter
urgency
is,
of
the
my
urgency is
learned
there, my
friend.
lord, because we vacation of the stay order, my lord.
But the
And there is a-
understanding of the matter was that the matter will be heard in totality. But there was an injunction order which was passed by the learned trial court. Against that, we preferred an appeal. Under order 43 rule 1R of grade 41(5), there was a stay of that order after hearing the parties. Against that, they went.
Stay in by the
Stay
high,
of the,
by the,
stay by the High Court. This
Trial
court-
court order, my lord.
Trial court order was stayed. Against that, they went to Supreme Court.
Supreme Court dismissed that their.
No, they disposed of
IFL.
the SLP panel.
Dismissing their particular that it was not entertained. They said that you can go ahead before the learned High Court and whatever the proceeding you can mention before the High Court. So
Not-
accordingly, matter has come up. Now they have filed another application before the court
Today,
for vacating of that order. For staying of that, the order passed by.
Ultimately,
this
the
court.
entire matter has to be
Entire
heard and
matter has to
said.
be heard.
But
At like,
Lordship may see the Supreme Court order, but it's very clear. It's not dismissed, my lord. It's disposed of. Your Lordship may, I may read the order, my lord. The trial court by an order dated 19 April 2024 granted an injunction against the publication of allegedly defamatory articles. The High Court by its impugn order dated 12 June 2024 stayed the order of the trial court and the listed the proceedings of
what was the order of the trial court?
trial
Trial court granted
granted
stay,
injunction in my favor, my lord.
ad interim stay.
Yeah, didn't say, my lord.
That stay was again stayed by
By
this
the
High
High
Court.
Court, my lord.
So now there is no stay.
No stay, my lord.
Okay.
So then my lord, the listed on 18 July 24, the proceedings are pending before the High Court. In view of the above factual background, we are not inclined to entertain the special petition at this stage. However, the petitioner may move the High Court for expeditious disposal of the proceedings. The High Court is requested to take up the proceedings with all reasonable dispatch. The special petition is accordingly disposed of, pending application also disposed of. So, my lord,
We
it
have
has
to
to be heard.
dispose it also.
no, you can, your lordship can dispose of, but fix a date. It is not a fixed date has been fixed.
Okay, let us, you suggested it.
My lord, date,
For final disposal.
7 or 8, my lord, August.
When?
8, my lord. 8th of this month.
So I will not be there.
8.
Next, so we got call.
Then, my lord, 22nd, my lord.
22nd PM. 22nd.
Okay.
22nd, my lord. There is urgency on our part, my lord. 22nd.
Okay, 22nd. On request of learned counsel for both the sides, let this matter be listed for final disposal. Or let this matter be listed for, let this matter be listed on 22nd August to 2028. On that day, endeavor shall be made for finally dispose of the matter.
There is an interim order which will be.
The
accepted.
interim order shall continue till next day.
No, 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 actually, after hearing the parties.
Lordship may not correct.
No, after hearing.
Yes, after hearing the parties, my lord.
Yes.
Final disposal after
No,
hearing.
no, after hearing, only
Today's,
starting, yes.
Today's heard Mr. J. Roy, learned senior counsel assisted by Mr. R. Hajurika. Also heard Mr. D. Das, learned senior counsel assisted by Mr.
S. Sharma.
S. Sharma. Remaining will remain same. After hearing learned counsel for both the sides, this matter is listed again on
Or
22nd,
22nd.
22nd.
Till then the interim order.
Till then interim order shall continue.
If you.
Oblige me.
Another matter, I'm sorry, another matter with my learned friend, there is one matter, item number,
324.
but she's there, I'll be there for some time. Because I think there is some urgency for the other side, no? We will,
We will see when it is.
we'll see, yes, because the other.
Yes.
My lord, item 11, my lord.
11, my lord, it was pending, my senior counsel also had to fix another matter. So consulting with my friend, that he's agreed on 13th one, next Tuesday. He agreed, my lord.
11th.
Yes.
Item number 11, heard Mr. M.Z. Kadir, learned counsel for the appellant. Also heard Mr. K.U. Ahmed,
My lord.
learned counsel for respondent number 2, as well as learned additional public prosecutor. On the request of learned counsel for both the sides, let this matter be listed again on listed for hearing on 13th August 2024.
Obliged.
My lord, another player, my lord, 17-18, my lord. My friend is there, my lord. Due to waterlogging last night, my lord, we could not attend the chambers, my lord, to go through the brief. That matter also maybe, my lord, on
Item 17 and 18 on
120.
request of learned. Have you informed the other
Yes,
side?
yes,
I am appearing for the respondent in both the matters. Lord.
Heard Mr. M.Z. Kadir, learned counsel for the appellant. Also heard Ms. R. Chaudhary, learned counsel for respondent. Learned counsel for the appellant has prayed for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed.
13-8. Lordship.
No fixed date.
On 20th, my lord.
No, it will be difficult. We have fixed so many cases which, so
Lordship.
we'll leave it on registry. We can fix the week. You
Yes.
choose the week.
In
Second,
fact, Lordship,
third week of,
I am for the
Yes.
respondent. I have urgency, but due to his problem, Lordship, I am giving consent.
On third week, my lord. The registry.
second week. Third week,
Third week, my lord.
Third week of Lordship.
August.
Lordship.
Let this matter be listed in the third week of August on a date to be fixed by registry.
Lordship can fix it on 20 August, Lordship. In third week, only 4 days are there as per this
20 August.
20 August, Lordship.
Let this matter be
Obliged.
listed on 20.
Obliged, Lordship. Both the matters, Lordship.
May I please, Lordship?
Lordship, can it be adjourned to the as part of lordship?
Not as part of.
My lord.
What is the issue, substantial question of law which was formulated?
Yes, my lord.
It
That-
does not appear to be substantial question of law. It is,
Yes, my lord. And additionally, we have also filed other substantial questions of law which are on record, my lord.
what?
On 16/6, we have filed, my lord, additional substantial questions of law. That is the main file, my lord.
No, what would be, because the substantial question of law which is framed. Accepted liability. is- Okay, you want an adjournment?
Lordship.
Yes.
Let it as a part, my lord. I have argued for it. And any date as per convenience of my land senior, my lord.
Any department by the court, lordship.
Heard. Mr. A.B. Chaudhary.
M.A.
Mr. M.A. Chaudhary, learned counsel for the appellant. Also heard Mr.
T.R. Gogoi, lordship.
T.R. Gogoi, learned,
Junior government advocate for all the respondents.
learned
Sorry, Lordship, all the respondents.
government advocate Assam for all the respondents.
No, sir. 4.55.
The hearing remained inconclusive. Let this matter be listed again after 2 weeks on a date to be fixed by registry as a part-heard matter.
Lordship, I am for 1, 2, and 3, lordship. Sorry,
One,
lordship.
1, 2, and 3
Yes, 1, 2, and 3, lordship.
as a part-heard matter.
Mass obliged.
Lord, he is on his way. I'll just apprise your lordship about the background of the case.
Who is on his
The appellant, man,
appellant?
counsel, man. He's. We have just
Who is the appellant?
J. Ahmed. Man.
Oh.
The counsel for the is J. Ahmed. He is on his way. Man.
Okay, you can,
I'll just, my lord, apprise your lordship about the factual aspect of the
yes,
case.
yes.
My lord, in the, my lord, second appeal, if your lordship kindly turns to page 60, my lord. Because that is the plaint and how the
Page,
60, my lord.
yes.
I mean, like, this is a case where there is concurrent finding of fact by the both the courts, my lord. Now, my lord, I was the plaintiff before the trial court. I have this Ramnagina Gupta, he had filed a suit. Now, suit is that this defendant number 6 and 7, my lord, they were the joint owners of a plot of land. It was amicably partitioned.
Justin.
My lord, he has.
No, no, come.
No, no.
Wait,
Apni come. My learned friend has come, my lord.
No, wait.
Apni come. No, just wait. Man, I have to play like this. Just plain to the house. Plain to the house. It's 60.
Yes.
The small landed friend has come. I was just taking a lordship to this party.
Yes, what was for suit was filed before the court of assistant district judge. Before the time.
Yes,
Trial court was the court of assistant district judge.
yes, ma'am. Civil judge.
You were the defendant
I'm the defendant. I'm the defendant number 1.
for suit was for what purpose?
Suit was for my lord. Logically, it is filed in page.
Declaration of right
Yes,
title and
madam.
interest and cancellation of sale deed
LD,
and for recovery of cash possession.
vacant position. Defendant number 1 and logically that point is basic. C. To pass a degree for delivery of vacant and khas position of the suit land to the plaintiff by evicting the defendant 1 and 2. Very important. 1 and 2.
In the prayer portion,
Yes. See, relief C, page 72 of the plate.
page number,
Page 72. This plate, kind of. Under the aforesaid circumstances, it is great that you may wanna be pleased, may be pleased. 1 A, B in C, madam.
so defendant number 1 and 2 were in
Position.
possession.
Yes.
What is the status now?
We are in position.
Defendant
Still-
number 1 and 2 are still in possession.
Still we are in position.
But my
Now-
instruction of the 2 is because this appeal is for 1 only. 2 has not prepared an appeal. This 2 has only filed a written statement along with 1. Apart from that, 2 has not taken any steps in this case.
I'll come, my lord.
Yes.
I'll, because
And as
because that is why issue was framed. The lawsuit can see issue number 2. Issue
No.
was framed.
Before that,
Yes,
before you brief me,
yes.
what substantial question of law has been framed?
Yes. 1, 2 and 3. 1 is, my lord, whether
Whether in view of.
number 1 is newly framed by your lordship. Earlier, there is a mistake. Whether the suite is, my lord, second suite is barred, since earlier suite is not a disclosure, because in the suite, the test number 6 is the plaintiff, the present defendant, respondent was the defendant of that suite, my lord, the defendant number 5. He filed a written statement along with counterclaim. Although the suit was decreed, but counterclaim was not disposed of. Within the pendency of the counterclaim, my lord, they brought another suit, my lord. And that now this proceeding has been going on because of filing. of the
Who
new-
filed the counterclaim?
The plaintiff,
Present plaintiff
present plaintiff,
filed the counter. Now, what was the earlier suit?
66 complete.
66 of? '94.
on earlier occasion, I given a chart, my lord. I think it is on record. Just
Okay.
for your lordship's
Mm,
convenience. my lord.
Just a minute, let me find out that. chart.
One page chart, my lord. In like
Subsequent.
Aneka, sorry. Aneka chart.
66/1994.
Aneka chart.
Yes, 66/1990.
94. In that suite, my lord, the
Who
check-
filed that 66/1994? Who is the appellant here?
Kunda Sen,
Abdul Hamid.
Yes.
Defendant number 1. And the suit was filed by Bhaurilal Kundalia,
Three, yes, 3, 4,
Vikram
and
and
5.
Rajkumar Kundalia,
Yes, my lord.
who are presently in this second appeal are arraigned as respondents.
Kondalia is one. Ram Nagina Gupta. Ram Nagina Gupta is he's the main, my lord.
No, let me understand. In this title suit number 66/94, who filed the counterclaim?
My lord, that was not a counterclaim.
That is your submission.
Yes, no, I will show from record also, my lord, that is not a counterclaim. Because I think, my lord,
But a issue has been framed
issue has been framed, my lord, don't know. whether
by
it
the
was-
trial court also.
No, trial court had not framed this issue. It was framed by this high court. only.
Substantial question of law.
Yes, substantial question. of law.
Okay,
Because
that is on their submission perhaps.
perhaps, my lord, because they have given this substantial question of law. And my lord, my lord, subject to your lordship's permission and my learned friend, may I just place the facts, my lord?
Yes.
Yes. Now, in this chart, your lordship, if see, on the left hand side, your lordship sees that, my lord, the 66/94. This
Yes.
chart which I have given, my lord, the 66/94 was filed by the three
plaintiffs.
persons. These 3 persons are the defendants in the case out of which the second appeal has arisen, 3, 4, and 5. At page 60, if your lordship kindly sees, my lord.
Yes.
That's your fine. The defendant number 3, 4, and 5, who are the defendants of this title suit number, my
Of
lord,
the subsequent suit.
a subsequent suit, they had
Subsequent suit number. title
subsequent
suit number
15 of 2017, my lord,
After renumbering.
after renumbering, my lord. Because at
Okay.
page 60, your lordship will find it's written as 177/94.
2007.
Original suit was of, my lord, 87. Initial, because on right hand side of the chart, your lordship will find title suit was 58/87. It was renumbered as title suit 177/94. And again, it was renumbered as 15/2007.
Okay.
Now, what had happened, my lord? These plaintiffs of the earlier suit
Yes.
is this
Bhaurilal.
Bhawarilal, this 3, 4, and 5 of the 15 of 2007. They had purchased a land, this my lord, plot of land. The dag number and patta number was different, my lord. And the respondent herein, he had also purchased a suit. the suit
Ram
land,
Nagina.
Ram Nagina, he had purchased a suit from the defendant number 6, my lord, of subsequent suit.
Okay. Biren Kundali.
This Ram Nagina had purchased the suit land from this Biren Khund, my lord. What is, my lord? At page 61, your lordship will find this Biren Khund is there. Page 61 of this memo of appeal.
Biren Khund.
Serious number 6. So what had happened, this Biren Khund, he had first sold a plot of land to this Ram Nagina Gupta.
Okay.
Okay, my lord, this Biren Khund had sold this land to Ram Nagina Gupta, and subsequently this Biren Khund had also sold a plot of land to this 3, 4, and 5. That is the plaintiffs of the earlier suit. And subsequently, Biren Khund, what he did, he executed a rectification deed in favor of this 3, 4, and 5. And by executing a rectification deed, what he did.
Where have you narrated this fact? This fact which you are narrating,
Yes, my lord.
whether in plaint or in appellate stage.
No, no, it is there, my lord, because this 66 of 1994, the entire case record has been marked as exhibit. It has been
In
exhibited.
this case,
In this case, because the first appellate court had taken note of this, my lord, this 66 of 94. So
Okay.
first of all, what this Biren Khan had sold this to Ramnagina Gupta, my lord, it was in the month of initially in the month of November, my lord.
there
Then
are three suits.
The second, yes, there were three suits.
Okay.
Now, this last one is not the subject matter of this case because the question with the substantial question of law which has been framed that there being a counterclaim on record of 66 of 94, whether a subsequent suit by this Ramnagina was maintainable or not. So that is why your lordship have to see the 66 of 94. Now this Biren Khan had first sold this land to the Ramnagina. Then thereafter, this Biren Khan had again sold this same land to this Kundalia brothers. And thereafter. Same land, my lord. It was sold and subsequently a rectification deed was executed. Now the rectification deed which was executed, that is very much similar to the suit land of this Ramnagina Gupta. So that is why there is a declaration for cancellation of sale. Now this Kundalia brothers, my lord, they have filed a suit. Their suit was that they have purchased the suit land from this Khand, my lord. This Kundalia brothers have filed a suit from Khand, and in that suit land, this Abdul Hamid and Alauddin Hakim, they were the trespassers over that plot of land. And in that case, my lord, this Ramnagina Gupta was made as a pro forma defendant. Now, this, my lord, suit was dismissed. It was this Abdul Hakim, this Biren Khan, they have prepared an appeal. And in appeal, my lord, it has been decided that the subsequent sale deed, which was executed by this Khan in favor of Kundalia brothers, that is not maintainable. I have the judgment of the appellate court also. So that issue is, my lord, settled. Now, against that, no appeal has been prepared before this High Court. So the issue that the sale deed executed by this Khan in favor of Kundalia brothers.
But it was not cancelled.
My lord, no, they have, because this suit was filed by this Kundalia brothers. They had filed a suit for enforcement of that sale deed and rectification deed. So in that case, the plaintiff will never ask for the cancellation of own sale deed. So that sale, the court said the sale deed which was the appellate court in the earlier suit, which was executed in favor of Ramnagina Gupta, that being in prior point of time, that sale deed will stand, and the subsequent sale deed executed by this Khan in favor of Kundalia brothers is not sustainable in the eyes of law. So that is the finding of the appellate court insofar as title suit 66 of 1994 is concerned. Now, my lord, I have a judgment of property. And this entire, my lord, record of title suit 66 of this, my lord, 66 of 94, that has been exhibited, and this record is exhibit 10. And
Exhibit 6, exhibit 6.
My lord,
No, in title suit 15 of 7.
Yes. This is the
Titles.
operative portion of that appeal which has arisen out of 66 of 94.
66 of.
I just highlighted that portion. The copy of 66 to Kunal file করেছে 66 to Kundalia তিন ভাইকে ফাইল করেছে And in this judgment, my lord, this appellate.
No, this is only submission.
No, my lord, your lordship is,
You read that. The finding is not there.
My lord,
No,
your
no.
lordship,
Page
because I
11.
am not wrong, my lord, your lordship may kindly take up the appellate court judgment. Matter is will be clear. Appellate court judgment, it is, my lord, they have filed a suit.
No, just a minute. There are many suits.
Yes.
yes.
Now,
The basically, my lord, two
basically
suits.
two suits.
66
66
and
66 filed by this
and
Kundalia brothers.
15 of 2007.
Two suits.
66 filed by this Kundalia brothers for enforcement of their subsequent sale deed. That suit dismissed against that this,
Subsequent sale deed executed by Ram Nagina Gupta.
no, executed by Count.
Six, that's not the.
Viren
Number
Count,
six,
Viren
executed by
Count.
Count. This Count had executed two sale deeds. Well, Count has
Earlier was in favor of
Ram
Ram
Nagina
Nagina
Gupta.
Gupta.
and subsequent was in favor of this Kundalia brothers.
Just a minute. The Viren counts are
First, this Mr. Count had executed his first sale deed in favor of Ram Nagina Gupta.
when it was executed.
This, my lord, it was executed on 30/11/1997, 78, man. 30/11/1978.
Aspect of what was the land area?
Land was, my lord, 1 kata 14 lechas.
And
One
thereafter Viren count again sold.
Yes, now thereafter, Viren count the 27/12/1978.
27.
12/1978.
Almost less than a month.
Yes, one is on 30th November 78, and the second one is on 27 December 1978. That is 1 kata 14 lechas of land.
Same area.
Yes.
Same land.
Same land. Because the first one, 1 kata 4 lechas, not 14. This 11/78.
And second one.
Second one, 1 kata 14 lechas.
So area is more.
Area is more. Now subsequently,
Area is more. That means 10 lechas land is more.
is more. Now what has happened? Then my lord on
This
40
subsequent.
yes,
sale
then
was
there is a
in-
rectification deed, my lord. On
Just a minute. Subsequent sale was in favor of Kundalia brothers.
Kundalia brothers.
Three. All three of them.
Three. Now, this subsequent sale deed which was executed by Viren Count in favor of Kundalia brothers. Initially, it was for 1 kata 14 lechas. Now, thereafter, Count has executed a rectification deed on 14/1/1980. On 14/1/1980. And
What was the rectification?
rectification was this 1 kata 14 lechas was converted to 1 kata 4 lecha.
Okay.
So that is why, my lord, this
That it
dispute.
becomes same land.
Same land, my lord.
And the
quan-
boundaries?
My lord, the boundaries are also same, dag numbers are also same. Now, as Count had executed a sale deed in favor of Kundalia brothers, the Kundalia brothers had filed a suit in favor of, my lord, this
Now, who is Abdul Hamid and Alauddin Hakim?
Where?
they are the
Present appellant. Present appellant.
He expired, now he is legally expired.
Against you, suit was filed by 1994, 66 of 94 suit was filed by Kundalia brothers.
yes.
On the, what was the allegation that they trespassed?
Yes,
For
that-
recovery
that-
of khas possession.
recovery of cash possession. So in that case, this Ram Nagina was also made a pro
Pro
forma
forma.
because there was a sale deed in favor of Ram Nagina which was executed in the month of November, 30th November.
Okay.
So that is why this Ram Nagina was also made a pro forma defendant in that case, 66.
Okay.
Now
Now in
that
66, what happened? Suit was-
66
suit
dismissed.
was dismissed.
Dismissed. Against that, my lord, this appeal was preferred by the appellant herein. Sorry, my lord, Kundalia, Kundalia.
The appeal is title appeal number?
My lord,
What was the number of the title appeal?
title appeal 19 of 2005. That is the judgment which I gave your lordship just now. Title
What
appeal
was
number
held in the
in this 19.
appeal was allowed or dismissed?
Appeal dismissed, my lord. This
Appeal
Kunda-
was dismissed.
Kundalia brothers suit was dismissed. They preferred an appeal. The appeal was also dismissed, and this appellate court, it has been discussed that as the sale deed of Kundalia brothers was executed at a later point of time than that of Ramnagina Gupta, so therefore that those sale execute rectification deed and sale deeds are not enforceable in law. madam. Kundalia brothers थे करा ना? Kundalia ने Kundalia Am I clear, my lord?
Yes.
Yes. So
Because before executing the second sale deed,
sale deed,
he
there
had
was
alienated his rights.
land to Ramnagina Gupta.
So he never had any right
Right title
for
interest.
transferring.
Yes, exactly, my lord.
Therefore, second sale deed and rectification deed was ineffective.
Ineffective. So, and that for enforcement of the second sale deed and rectification deed, they have filed that 66 of 94. And in that 66 of 94, this Ramnagina was also made a pro forma. And in that case, Ramnagina had given a written statement. Now, in that written statement, normally, my lord, in written statement, what we do, we say that it is therefore most respectfully prayed that your honor may be pleased to dismiss the suit with cost. But instead of giving that prayer, the written statement, my lord, it is on in the record only, my lord. This is in this 66 of 85. But this is the, my lord, your,
Written statement is in the memo of appeal? No.
no, it is, I don't think, my lord.
That was 66. No, it is not yet.
It is not
But it
there.
is, that record has been exhibited.
My lord, this is the, my lord, very fragile paper, my lord.
You keep it. You just tell me what.
No, in the prayer portion, my lord, the prayer,
The prayer was there in written statement.
yes, only the prayer was there. Now,
What
just
was the
because
prayer?
the prayer was the plaintiff should be dismissed with cost to declare that the pro forma defendant 5 is entitled to khas possession over the suit land after evicting the defendant number 1 and 2 on the basis of pro forma defendant, right title interest, any other relief. Now, just because this prayer was there, it has been construed that it is a counterclaim.
Whether
Now-
trial court held it to be a counterclaim
No, my lord.
anywhere in the orders.
No.
No, no, it is mentioned.
That
It
is
is
also-
mentioned, yes. Loss of see appellate court judgment, I am.
No. Don't mix it up.
Yes, it is mentioned in the judgment, appellate court judgment also that
But whether in
they have
trial,
filed a counterclaim.
whether in trial court during
I-
the
I-
proceeding of the trial,
Yeah.
day-to-day orders,
Nothing.
Whether-
It was only counterclaim,
whether
my lord.
any court fee was paid.
No, that is why, my lord. What is a counterclaim, my lord? Counterclaim is akin to the suit. Now, in a suit, my lord, there has to be a, my lord, although when we file a counterclaim, it runs parallelly like a separate suit. Now, if there is a suit, my lord, court fee has to be paid. My lord, if the court fee has to be paid, there has to be an order that yes, court fee has been paid, anything. There has to be then, my lord, so what is the declaration? It is a written statement. Everything is written statement. Only this prayer portion. Just because of this prayer portion,
No,
whether
answer my query first.
yes, my lord.
Whether the trial court in 1966,
Yes,
In
issue has been
yes.
framed. Page 32 in lawsuit. Page 32.
page 32,
Yes, my lord. Issue has been framed in this agreement.
issue was framed.
Yes, page 32, my lord.
Page 32 of the is also this case, my lord. This page 32 is not of 66.
No, I am asking about 66.
66 is this record, my
Don't
lord.
mix up.
No, yes, my lord.
66
66
not with
entire
us.
record is there. May I help your lordship? with
Because
this?
in 66, first we have to
We have to see whether
come to
there,
a finding that it is a counterclaim.
yes, my lord.
Only then the substantial question of law will stand.
Yes, my lord.
If we come to a finding that it was not a counterclaim,
Counterclaim. Yes.
then it will collapse.
College. And the judgment which has arisen out of 62 in appeal, that is before your lordship, my lord. In that judgment, my lord, I have got.
My lord, only one point I can raise. Before clarification, my offense correct. The lordship kindly see the order judgment and decree passed by the in title suit.
Where there are many title suits.
No,
Which title
in
suit?
that fifth case.
You number
15
that.
15/07, page
15
32.
No, we have not yet come to 15/07.
Not
We
this.
will come to that.
Yes.
First, let me understand
this 66,
66
because
of
yes,
94,
if your lordship goes to
which
the
was
order.
filed by Kundalia
Kundalia
Brothers,
yes.
where you were the main defendant.
No.
Where you were the main defendant
Correct.
and Ram Nagina was one of the pro
Pro
forma
forma
defendants.
That suit was dismissed, but in that case, my friend's client has filed a counter. This is that.
No, if
Yes.
there is a
Now,
counter
whether there was a counterclaim or not,
Yes, ma'am. But finding is there in the court below, and
Where-
as well as.
where
appellate
is
court
the
below.
finding? You tell me where is the finding?
In this case.
Not in this, we'll come to this case later on.
66.
In 66, whether the trial court held in any of its orders that defendant, pro forma defendant had filed a
Filed a-
counterclaim. Then
Because
what,
in the
in the appellate court judgment,
judgment at page 4, which a
appeal was preferred by Kundalia
Kundalia
Brothers.
Brothers. Now, at page 4 of this appellate court judgment also, your lordship will find that no issues were framed by the trial court. At page 4, which I have given, my lord. My lord, this is more legible. Lordship may take this one, my lord, I think.
Yes, that would be.
The same
It
thing.
घोड़ा दियो.
Yeah. Because this is, that will strain your lordship's eyes, my lord. At page 4, your lordship will find.
Yes.
Because these are the issues which were framed by the learned trial court in 66. Now, had there been a counterclaim, my lord, the issue ought to have been there
Regarding counterclaim.
regarding
So
counterclaim.
your issue, submission is no issue was framed.
No issue was framed. Now, issue number 1 is whether the pro forma defendant number 3 had right-titled interest over the suit land, whether the defendant number 1 and 2 are trespasser, whether the defendant number 1 has been possessing the suit land since 3571 adversely and acquired right-titled interest over the suit land in suit, whether defendant number 1 admitted the title of the plaintiff in his written statement in 1679, whether plaintiff have acquired right-titled interest over the suit land on the basis of sale deed so and so, whether the plaintiff are entitled to get any degree to what relief. So, and another issue is whether the present suit is maintainable in view of withdrawal of earlier title suit number so and so by the plaintiff. So these are the issues, my lord, which were framed by the learned trial court in 66.
Before this also earlier some title suit was there.
Before this, that were there, that is, my lord, this one. This one, this down, which I have down below, my lord, lordship is 16 of 79. Lord, in this chart, my lord, in chart which I have given, my lord.
Yes.
Yes, down below. So there, that suit was filed by this, my lord, this Kundalia Brothers against the appellant hearing.
Okay,
Suit
what,
for eviction of defendant number 1 from the suit land that was withdrawn. Because once it has been held that the sale deed executed by Birend Count in favor of Kundalia Brothers is not enforceable in the eye of law. So therefore, my lord, this Kundalia Brothers, they will not get any right to maintain a suit for eviction of my learned friend's client. So probably because of that, my lord, that suit was withdrawn. Now, in the suit which was withdrawn, this Ram Nagina was never a party. WS machine order sheet is for the same. WS की मैं मार्क receive करूँ हाँ কিন্তু হাজিরার ফাইল করি আছে তাদের ফাইল এবি সেকেন্ড না কোনটো সাইজ হাজিরা বলে রাখুন So
this appeal was also dismissed.
yes, this appeal was also dismissed. So now, my lord, as this appeal which has been preferred by Kundalia Brothers, as it was dismissed, suppose in this case, and in that case, my lord, the subsequent of subsequent sale deed enforcement.
Whether in this appeal, there is there any mention that the pro forma respondent number
This Ramnagina, about
Ram-
Ramnagina Gupta.
Ram Nagina filed a counterclaim?
I didn't find it, my lord. In this one, I didn't find anything like that.
But it is clearly mentioned in the present.
We will come to that.
Yes, it is
In
clearly
that,
mentioned.
in that, there is no mention
No,
about
my lord, I
counter-
didn't. Had there been a counterclaim, at least issue ought to have been there. whether the plaintiff, this respondent number so and so, counterclaim of the so and so.
So it was not raised by any of the parties.
Not raised means, my lord, my respectful submission before your lordship is that it was never a counterclaim just because this prayer was made. So, my lord, it was, my lord, they've taken it that since a prayer has been made, we made a prayer in the suit, so it is a counterclaim.
It constitutes a counterclaim. If a prayer is made, it
Without,
constitutes a
con-
counterclaim.
without
What
court fee,
constitutes
my lord,
counterclaim?
how can we consolidate it? And without,
CPC, what CPC says?
my lord, without payment of court fee, how can a counterclaim, my lord, proceed?
It was like, other judgment of fallacy, huh? The 6 is judgment of fallacy. It is some consideration.
File ABCS. It took a 66 or judgment.
Number
66 or 1905. Title appeal 1905. It was in the appellate court's judgment passed in, my lord, this which has arisen out of 66 of 94. My lord, I didn't find anything about this counterclaim, my lord. And in this, my lord, appellate court judgment of, my lord, which has arisen out of 66, at page 11, my lord, the appellate court has also discussed that the sale deed which has been executed in favor of Ramnagina Gupta, that has been validly executed. Page 11, my lord. Of this appeal number 19 of 2005, at page 11, lordship will find, where page 11, para 11, my lord. Evidently, my lord. What you got it now? Evidently, the suit property was validly transferred in favor of pro forma defendant number 5 by the pro forma defendant number 3. My lord, this 5, I think this is a typing mistake. It should be 6 if we go by this array of parties, because 5 is this some Gopal Krishna Jyoti is not. This typing may be typing mistake. So para 11, my lord, evidently the suit property was validly transferred in favor of the pro forma defendant number 5 by the pro forma defendant number 3, the admitted owner of the suit land by exhibit A. That being so, after transferring the suit land by exhibit A, there was no right title or any saleable interest of the pro forma defendant number 3 over the suit land. That being so, the exhibit 1, the sale deed executed by the pro forma defendant number 3 in favor of the plaintiff appellant or its rectification could not convey any title to the plaintiff appellant in as much as the vendor pro forma defendant number 3 himself had no title over the suit land on the date of execution of exhibit 1 and 2 in favor of the plaintiff appellant. Thus, evidently, the exhibit 1 and 2 failed to convey any title over the suit land to the plaintiff. In the above facts and circumstances, one can safely hold that the plaintiff appellant in this instant case failed to establish his right, his title.
Ultimately, the appeal was dismissed.
Dismissed, and in that appellate court judgment, my lord, this has been discussed regarding the, as your, it has fallen from your lordship's mouth, my lord, that being a subsequent sale deed, that cannot be enforced. So same, my lord, view was by discussing all those things, the appellate court had ultimately dismissed the appeal filed by these Kundalia brothers.
Yes. Thereafter,
Now there, yes,
In 15/2007,
7, my lord.
which was filed by Ramnagina Gupta.
Yes, Guram Nagina. So because there exists a valid sale deed in favor of Ram
This
Nagina.
was also dismissed. 15. 15 of.
No, my lord, suit was decreed, appeal was dismissed.
Suit was
Suit
decreed.
was decreed on 28/2/2011. The suit was filed by Ram Nagina for enforcement of his sale deed and recovery of possession. And against that, the appellant herein had preferred a first appeal, and that was dismissed on 21/12/2013.
Against that dismissal,
Against that
they have
dismissal,
preferred
they
this.
have come. Now, their contention, appellant's contention is that as there was a counterclaim in this 66, so my lord, appeal goes, suit goes, but that counterclaim remains. So in view of the pendency of that counterclaim, whether Ramnagina could have filed a subsequent suit. That is why this issue has been framed.
That issue was framed in title suit to 15
No,
of.
not before this court only.
But not before.
No, not before.
In the second suit,
No, in this,
this plea was not taken.
No.
Neither in the appellate court.
No,
Second,
because
in the second round of litigation,
because
when the appeal was filed against 15/2007 judgment,
my lord,
before appellate court, whether this plea was taken, that a counterclaim is still pending in 2000.
at page 12 of the memo of
It is
appeal.
mentioned in the
Yes.
judgment.
Where?
At page 12 of the memo of appeal, your lordship will find the issues, my lord, of the appellate court. The appellate court. It is, it will be left. Lordship got, my lord, page 12.
Yes.
Page 12 of this memo of appeal, my lord.
Yes,
Yes, this is the, my lord, judgment which has been assailed before this honorable court, my lord. Now, issues are whether the plaintiff has any cause of action for the suit, whether the suit is barred by limitation, whether the suit is hid by principles of estoppel and or waiver, whether the suit land is also a subject matter of TS 66 of 94.
What was the finding as regards issue number 4?
Issue number 4, my lord.
Suit, whether suit land was same or not?
Yes. Regarding issue number 4, we have got
That issue has not been at all discussed by the
Trial court.
trial court. Not discussed. it is
page
mentioned.
16, my lord. Page 16. Page 16, my lord, issue number 4. Page 16 of the memo of appeal. Lordship got it, my lord?
Yes.
On going through the impugned judgment, I find that the learned Munsif has not elaborately discussed the issue. I have gone through the record of title suit number 66 of 94, which is exhibited as exhibit C, and the judgment and decree dated so and so in title suit number 66 of 94. Learned court below framed an additional issue as to whether defendant number 1, present appellant, have been possessing the suit land since so and so adversely and acquired the right title interest over the suit land as in issue number 3. In that suit, the present respondent number 1 filed his written statement with counterclaim. In so and so, that title suit number so and so was filed by the present respondent number 3, and present respondent number 1 filed written statement with counterclaim as pro forma defendant number 5, and the present respondent number 1 in that suit has prayed for a decree that he is entitled to khas possession over the suit land, and after evicting the defendant number 1 and 2 on the basis of his right title interest over the suit land. In that suit, the present respondent number 1 produced his original certified copy of sale deed number so and so, which is marked as exhibit A. In that suit, the plaintiff has also produced the certified copy of sale deed and rectification, which is marked as exhibit 1 and 2, but the plaintiff have not assigned any reason whatsoever for exhibiting the certified copy of the sale deed, while the present respondent number 1 has stated that his original sale deed number so and so is filed in title suit number so and so. Record of this case was called for, and upon perusal of the record, the learned appellate court ascertained that sale deed number so and so has been produced and exhibited as exhibit 1 in this suit. And learned trial court had held the certified copy of registered sale deed are not public documents of the Indian evidence. Evidence accordingly, the certified copies of the said instruments are not admissible as evidence in connection so and so has been referred to in this suit. At the time of cross-examination, the pro forma defendant number 5, the plaintiff had not successfully diminished the testamentary value of exhibit one in any manner, nor has prayed for any decree of cancellation of the registered deed number so and so, and that the learned court below held that the sale deed number so and so is a valid and binding sale deed. Though the trial court in the suit held that sale deed number so and so executed by Biren Count in favor of respondent number one is a valid and binding sale deed and dismissed the suit of the plaintiff, but no decree was passed on the counterclaim of the present respondent as the pro forma defendant number 5 in 66 of 94. Though the parties of the present suit and subject matter of the present suit as well as title suit are same, but the learned trial court did not decide the issue of counterclaim raised by the present respondent number one, as the issue of counterclaim was not finally decided and so and so. Hence, the present suit is not barred by res judicata under so and so. Now here also, my lord, although it says about counterclaim, my lord, no finding that what was the counterclaim, whether there was any issue regarding that counterclaim. Now, this is issue number 4. Now, issue number, my lord, 5. Whether the that page 12, my lord, whether the suit is maintainable in law in view of counterclaim taken by the plaintiff is title suit 66 of 94. That's it. Issue number 5, my lord. Now, issue number 5 is at
Actually, in 4,
17.
in page, in issue number 4 itself, it has been decided.
Yes, issue number 5. It's 7. Five has not been discussed. My lord. Five. Discussion of the decision.
If you also kindly see the page 12 of the judgment.
Now in my lord, records of 66 of 94, lordship has to ascertain whether there was any counterclaim or not.
Okay.
My lord, we have flag marked it, my lord, this written statement. But whether anybody from the order sheet, it has to be seen, my lord, whether
That was treated
as a counterclaim or not.
counterclaim.
Because this written statement was filed up. That August 84. August 80, 94, 94. August 94.
Okay, what was decided in the appeal? Ultimately, appeal was dismissed. In the second round of litigation, appeal was dismissed. On what ground?
On ground that
What plea you took before the appellate court? What plea you took before the appellate court? What was your stand? The suit was decreed in favor of Ramnagina Gupta on the strength of the
Sale
sale deed as well as his possession
The possession is in his favor.
in their favor.
Now, in the written statement filed by the appellant hearing before the trial court, the appellate had said, my lord, that he had allowed this defendant number 2 to reside in that plot of land. Now, my instructions are that this 2 has expired and there is no legal heirs or representatives of the defendant number 2 over that suit land. So, and this defendant number 2, he has, except for filing a joint written statement, 1 and 2 had filed a joint written statement. two had never adduced any evidence nor has assailed any order before any court. Only this joint written statement has been passed in the suit filed by Ramnagina. Order sheet is there. Order sheet of-
Yes,
Able to go on after,
yes, Mr. Ahmed.
my lord.
Now you can make your submission.
So briefly, my lord, in a nutshell, these are the facts of the case.
My lord, now, yes, my lord. The lordship kindly see,
What the other two,
first substantial question of law.
yes,
In the first substantial question of law, in this case, the trial court as well as appellate court framed the issue about the filing of counterclaim. That issue has been framed, but the court below as well as the court below failed to discuss the issue number 4. That about counterclaim. No finding has been given. And now in appellate court, your lordship also kindly see, no finding has been given about issue number 5. You'll also kindly see, just I try to satisfy your lordship. Just page 12.
no, but the issue before us is that assuming that there is a counterclaim,
Counterclaim.
during pendency of the counterclaim,
Second
second
is
suit
barred.
is barred or not.
Yes. that
But
is-
for that, on factual grounds,
Yes.
on facts, it appears that there is no counterclaim.
Yes. ma'am.
Then this, whether
Question
this
will go, my lord.
substantial question of law would stand. And whether there is a
Even-
counterclaim filed or not, it has to be ascertained from the suit in which counterclaim was filed, not in a different suit. Your submission is in a different suit, subsequent suit, that plea was taken regarding counterclaim. But in the suit in which you are
Applied.
saying that counterclaim has been filed,
66 of-
no such issue was framed. Yes,
Now, my lord, there is another aspect of the matter. Even assuming, my lord, there is a counterclaim. Now, this Ramnagina has filed a suit for enforcement of a right, legal right, which has emanated from a sale deed executed by Khand in favor of Ramnagina. This Ramnagina has filed a suit for enforcement of his right, which has emanated from the sale deed executed by this Khand in favor of Ramnagina. Now, this 66 of 94, this suit. Lordship,
sound is not the party.
well, in this chart, the parties are there.
Hmm.
Now, the chart which I have given to your lordship.
Yes.
Yes. Now, this 66 of 94, that was a suit between these Kondolia brothers.
Sound is not a party.
No, my lord, yes, this Birendranath Khand is also a party. This Sharma and Khand same, 3, defendant number 3. Birendranath Sharma and Birendranath Khand is one and same person.
Okay.
Now, in the suit of 66, my lord, Ramnagina was a pro forma. Now, assuming that Ramnagina had filed a counterclaim, this counterclaim would be against Kundolia brothers, not against, my lord, the appellant hearing, because the co-defendant, a counterclaim is not maintainable against a co-defendant. Am I clear? First of all, we have to ascertain from the records of 66 of 94 whether there is a counterclaim or not. For the sake of argument, even assume that there is a counterclaim. So in that case, this counterclaim of Ramnagina in 66 of 94.
Now, whether the WS filed by Ramnagina may be treated as a counterclaim or not.
That means even if it is a counterclaim, that counterclaim will be against Kundolia. That counterclaim will be against Kundolia. That will not be against this main defendants of 64, 66 of 94. So, my lord, let us assume that that is a suit counterclaim.
May record video.
So,
You
my
have,
argument-
you have flagged that
no, this written statement has been flagged.
where the counter,
written is on basis of performance defendant number 5. It was no.
Right, no?
5.
Oh, right, no. Ramnagina Gupta, Already in this appellate court judgment, this pro forma 5 has been referred further because of this typing mistake in the written statement. It has been written as for 5. In fact, it is 6 because this written statement is of Ramnagina Gupta. Verification, your lordship will find Ramnagina Gupta. So, my argument would be, even assuming that yes, there is a counterclaim by this Ramnagina in 66 of 94. So that counterclaim will be against Kundalia brothers. Now, if that counterclaim is against Kundalia brothers, there is no question of a bar being created for Ramnagina filing a suit against this appellant here in my lord. Because this count they had sold and he has washed off his hand, he has gone. Now that first is Ramnagina and subsequently this Kundalia brothers tried their luck, they failed. Now this 1 and 2, they are in being trespassers in possession of their land. So this Ramnagina had filed a suit for eviction of defendant number 1 and 2 from the suit land and recovery of khas possession. Hello, may I help your lordship with the orders of 66 of 94? Because
Yes.
when the written statement was filed on that day, what is the order which has been filed by the court?
He record to Tadyo.
But in written statement, in prayer 2, they mentioned that to declare that the performance defendant. To declare, he said declaration, my lord. So subsequently it is a counterclaim, my lord.
No, proper count.
No,
They have to declare that the performance defendant number 5 is
but
integral to
you-
khas possession.
Mr. Das is making submission as per order 8, rule 6A.
Yes,
Counterclaim can be against plaintiff only.
21. First of my
That
two
is his-
submission, my lord. First of all, my lord, just because the defendant has written in his, my lord, written statement to declare so and so, my lord, until and unless, my lord, when we institute a suit, my lord, the procedure is there, we have to pay court fee, someone has to go. Now, counter claim is parallel to a suit. Now, in order to constitute a counter claim, we have to pay separate court fee, my lord. It cannot be just because the plaintiff has filed a suit against the defendant, we will file a counter claim and the counter claim will proceed automatically. So, in absence of any payment of court fee and there being a specific order from the court that register it as a counter claim, it cannot proceed as a counter claim.
It shall be governed by all rules applicable to plain.
Plain, ma'am. Exactly, ma'am. I'm grateful to your lord. And my second limb of argument would be that even assuming that there is a counterclaim. Now, counterclaim, my lord, will be maintainable against the defendant will file against a plaintiff. Counterclaim is not maintainable against co-defendant. Now, even assuming lordship has seen who are the parties in 66 of 94. Now, even assuming that yes, there is a counterclaim which this Ramnagina had filed in 66 of 94. So, at best, that counterclaim would be against this Kundalia brothers, not against the appellant herein. So, how come the pendency or non-disposal or whatever may be of the counterclaim in 66 of 94 create a bar in filing a subsequent suit by plaintiff? That is my argument.
Since my friend claim for declaration, it will be a counterclaim, number 1.
Okay.
Number 2, in suit, whatever may be plaintiff, I may be plaintiff or not, I may be a defendant. But that is applicable to me also. It is applicable in the suit, my lord. Now, section 10 of the CPG is completely barred. Second, he should have, yes, if it is not against me, my lord, he should have pursued that, my lord. Why he filed a fresh suit? He should have pursued that suit.
Now, against whom I will pass?
Counterclaim.
Against whom I will.
Against that, my lord, against the plaintiff, against that.
This Kundalia
defendant, my
brothers,
lord.
no, they are not in possession. He is in possession. So if I
That is
want to
why-
get back the possession, I will have
That
to
is
file
why
suit against him.
he prayed for declaration, my lord. What is the means? Declaration by the evicted defendant number 1. In the reason he prayed for declaration, my lord. So it is exactly applicable, my lord, it is a counterclaim as, and it is barred under section 10 of the CBC.
Okay.
It cannot be said that that counterclaim is not applicable in against me because I am the party of that suit, main defendant. I have the main defendant that suit also, my lord. The day should pursue that suit.
What else your submission?
My submission is, my lord, the counter, there in title suite number 66, the defendant may file a counterclaim along with the written statement. Although it is a written statement, but he has said declaration, my lord. He said declaration about, my lord.
This is the this WS was filed and it is yellow on 10/8/84, and this is the order of 10/8/84. If it would have been a counterclaim, the court would have ought to fix the WS on counterclaim, but it is fixed for issues and documents. So
So court has committed that mistake.
no, when court has committed the mistake.
It is the duty of the parties to point out the code.
Have you got it, my lord?
Yes,
Oh,
yes.
So even assuming, my lord, my learned friend's argument that yes, there it was a, my lord, counterclaim. So if the counterclaim was registered, the next date ought to have been for WS on counterclaim. And the court ought to have, if this Ram Nagina had not paid the court fee, the court would have directed, my lord, for payment of court fee. And in spite of direction, if the court fee was not paid, then order 7, rule 11, that counterclaim goes.
And my lord,
So, my lord, let my learned friend demonstrate before
Yes,
this
sir.
honorable court
Yes, I am.
that yes, it was a because
Yes.
it can be not from the written statement of this Ram Nagina, my lord. He may write whatsoever or many things. It is from the court records. It has to be seen whether it was a counterclaim, my lord.
Where is the plaint in subsequent suit? In memo of appeal?
Or
In memo of appeal, my lord,
So-
at page 60.
Okay, this is the claim. Yes, Mr. Ahmed.
My lord. Now, so far is my submission, my friend submitted that it is not a counterclaim. But your lordship kindly see page 5 of the written statement. See, he to declare that the former defendant number 5 is intended to cast
In the
position
prayer
over the
portion.
sweet land. Prayer, page 5. After evicting the defendant number 1 and 2, on the basis of the performer defendants right title in interest of the sweet land. So it necessarily it is a counterclaim. This is a counterclaim. If it is a counterclaim, then second suit is barred under section 10 of the CPC.
Anything else?
Under section 10, you will also can see under section 10 of the CPC. That's it is barred. Now we will also can see second substantial question of law. My friend says that the defendant number 2 did not take any steps because he already expired. How can he take steps, my lord? He has not been, his legal has not been substituted. It is pending. You also can see, we have taken a specific claim. Now we also can see
No, defendant number 2, in which case? In title suit?
title suit Present title.
Present titles.
Yes, present title. Defendant Alauddin Hakim. Defendant number 2, Alauddin Hakim, my lord.
Now, is it a substantial question of law? Where, because this is not disputed, where there are more than one defendants, one defendant dies, and right to sue exists in relation. in
It will
regard
await
to
so far as that defendant is concerned, my lord.
remaining the
The suit will proceed.
suit will proceed.
Proceed.
No, it is wholly, it is wholly evident.
Where is the
It
law?
is
On
wholly
what
evident.
basis?
Your lordship, can you see? I will place some judgment, my lord.
Not passed.
Yes.
Now, before that, my lord, section 22, order,
Order 22.
order 22, my lord, rule 4 is to be.
Yes. Read rule 4.
My lord. Order 22, rule 4. Procedure in case of death of one of several defendant or sole defendant. Where one or two or more defendants dies and the right to sue does not survive against the surviving defendant or defendant alone or sole defendant or sole surviving defendant dies and the right to sue survives, the court on an application made with valve shall cause the legal representative of the deceased defendant to be made party and shall proceed with the suit. Now, 4, my lord. The court, whenever it thinks fit, may exempt the plaintiff from the necessity of the subsequent legal representative on inside defendant who has failed to file written statement or who, having filed it, has failed to appear and contest the suit at the hearing, and judgment may, in such case, be pronounced against the said defendant, but it is not that case. It is against they should substitute. They should not be substitute, my lord. Where within the time limit by law, no application is made under sub-rule 1, the suit shall abate against the deceased defendant.
So against him it will abate. Against you it will continue.
But here a finding, I found one judgment. If one defendant is abated, it is abated as a whole.
Which judgment?
Citation.
Citation to court
If
of
it is
law.
inseparable.
मैंने कोई तक मैं लिखी नहीं।
Yes,
You which judgment you are relying?
I two seconds I given, 2 seconds I already.
But which one you are relying?
Relay.
Yeah. No, it is.
Which one you are relying, which paragraph you are relying, you have to make submission.
Therefore, Lordship, kindly see. Paragraph 17 to 21.
In which case?
In 2010, 11 SCC,
Which para you are relying, para?
17, 18, 19, and 20.
Page number, page. The page, citation page.
Yes. 476.
476. Two thousand ten.
Seventeen makes it clear. You read 17.
18 also clear. Therefore, in the law on the issue, stands crystallized to the effect that as to whether non-substitution of so respondent dependent would abate the appeal into two or only for the deceased respondent dependent depends upon the facts and circumstances of the individual case. Where each one of the parties has an independent and distinct right of his own and not independent upon one or the other, not the parties have conflicting interest, the appeal may abate only qua the deceased respondent. However, in case there is a possibility that the court may pass a decree contradicting to the decree in favor of the deceased party, the appeal would abate in 2-2. For the simple reason that the appeal is a continuity of suit and the law does not permit two contradictory decrees on the same subject matters on the same suit. Thus, whether the judgment decree passed in the proceeding vis-a-vis remaining parties would suffer the vis-a-vis being a contradictory or inconsistent decree in the relevant test. In the instant case required to be examined in view of the aforesaid settled legal propositions, every co-owner has a right, you also kindly say, to possession and enjoyment of each and every part of the property equal to that of other co-owners. Therefore, in theory, every co-owner has an interest in every.
Now, what was your basis of your,
Because.
on what basis you
Because
claimed
defendant number 1 and 2 are in possession.
possessory right?
Possessory right.
You die, possession goes.
But
If you don't have any legal heirs.
There was also no contract.
I have the defendant number 2 died. His legal representatives are there. They should be brought on record because they died during the pendency of the suit. Let they say something, they may not be right.
Okay, then.
They should be back on record.
Assuming that it abates against defendant number 1, decree cannot be executed against defendant number 1.
He is defendant number 1.
I am defendant
No,
number
defendant number 2.
Yes, so
Defendant
it is-
number 2.
Now, whether my learned friend is arguing for 1 and 2, let him make it clear.
So 1 and 2, my
Whether
lord,
he is for
suppose
1 or
a decree has been passed against that person, my lord. Against that person.
Therefore, it will not be executed against that dead person.
That person.
But against you.
Oh, my lord. Then now question it. Now the land 1 kata 14 lasas. Who were in whose persons? That question come, my lord.
that the executing court will.
Execu-
issue, my lord.
Then that question come arise. Which part of land is to be evicted?
Did you
took this plea before the first appellate court.
Yes, this is the, that is why issue was framed by this, my lord.
First appellate court, what it decided? On
First appellate court, Lord Ship, kindly see.
what was the issue and how
Yes,
it was
yeah,
decided?
first appellate court issue, my lord. Lord Ship, kindly see. Issue, page 12. Page 12, my lord. Issue number 1, whether the suit is barred by limitation, whether the suit is hit by the principle of stubbles and or waiver, whether the suit land is also subject matter of so and so. That issue was not discussed by the trial court. Whether the suit is maintainable in law in view of the counter claim taken by the plaintiff in test number so and so. That issue was also not decided in appellate court also.
No, my query is
Now,
whether you took the plea before the appellate court. You took that ground that as the suit abated against defendant number 2, whether that you took that plea, you are raising that plea before the second appellate court.
yes, for the reversion, can you see? Page 13
Page 13
of the appeal.
Yes.
Paragraph 13. Being aggrieved of the said judgment degree, the defendant number 1 filed this appeal on the following grounds. Further, the learned court will aid in law as
No,
well as in
where
facts.
are you reading?
Page 13. In appeal. RSA memo.
Yes. Page 13 discusses issue number 7 only. RSA.
My lord, RSA 116.
Yes, I am also with RSA 116.
General page 13.
But these are the grounds which they have taken. Court had
I'll
quoted
take
it.
it. Page 13, you also got it.
Page 13 is
Something different.
Of this memo.
Memo of appeal. It is the Alexa.
page 13 actually is the judgment in title appeal.
Oh, no,
Yes,
no, letter. Yes, judgment and memo appeal.
In that judgment only it has been.
It is quoted. Judgment and memo of appeal, page 13. Paragraph 3, 13.
Second para, being aggrieved, my lord. It starts with the word being aggrieved. Second para.
Yes.
Yes, being.
Para 13.
Being aggrieved.
Being aggrieved, you also got it.
Yes.
Being aggrieved, the said judgment and degree, the defendant number 1 has filed this appeal on the following grounds. Further, the learned court will read in law as well as in facts. Further, the issues are not properly and elaborately discussed. Further, let brain count the defendant number 6 executed all cell deeds and the deeds of rectification. He is the main pillar in this episode. Brain count died during the pendency of the suit, and his hairs were not substituted. That's one matter. Similarly, Desmond 2, Alauddin Hakim, who was the defendant number 2 in the suit, contested the suit and filed written statement. He too died during pendency of the suit, but his legal hairs were not substituted. Therefore, the Desmond 2 and 9 are necessary parties. In their absence, no effective decree can be passed, as the learned Munshi passed the judgment on 28/2/11. It has become a judgment against 2 dead persons, which is void as per law. Further, the plaintiff now, respondent 1, alleged in the plaint of fraud and conspiracy against the division number 6 count, but the learned court considered brain count as a proper party and not a necessary party, and passed the judgment. My lord, that brain count has executed the cell deed, my lord. He is a necessary party, my lord. He is also, his legal has also not.
That is not the
substituted.
issue before us now.
That issue has not framed.
That is
That is
not
right.
the issue. We cannot
That-
stray and take up every issue. What has been formulated, you may argue on that.
Then, dependent number two. He's the necessary, he's the necessary, but he's the every right, he has the interest over the sweet land. In absence of him, his legal representatives are there.
Okay, okay.
Now, in this regard, my lord, I feel some judgment regarding abatement. Now, since my lord, here you must see any other substantive question of law is to be framed by this Honorable Court if found it is left out. Now, Lord, kindly see that issue has been discussed. Learned appellate court will have discussed regarding the necessary parties and not necessary parties in issue number 8 and 9, page 20.
Page 20.
Page 20.
Yes.
In examination sheet, the defendant number 1 has stated that the owner of the sweet land died on 14/4/2005 and his legal representative were not implicated and therefore that suit is liable to be dismissed. Learned counsel for the appellant has submitted that there cannot be a suit against dead persons and the suit is liable to be dismissed. On the other hand, learned counsel for the respondent plaintiff has submitted that the defendant number 6 is not a necessary party and his absence will no affect the suit. From the pleadings of the plaintiff and defendants, it is apparent that plaintiff has not claimed any relief against the defendant number 6.
Who is defendant number 6?
6 is the count, who is the executor of the sale deed. He is the main owner. He executed the sale deed.
But sale deed is not in question.
Then it is not in question.
This is a suit for recovery of khas possession, declaration of right, title and interest. Nobody against you.
But
Sale deed has been, the validity of sale deed has been decided
In that
in
66.
earlier suit. In this suit, sale deed is not in question. Whether you are an encroacher or trespasser, that is the issue.
Now, let's look at this here. Now, that was an issue. Yeah. Philosophical is page 12.
Page 12.
Page 12. That issue has been framed regarding sale deed, my lord. Paragraph 10.
Paragraph 10.
Paragraph 10. But again, by order dated 7/3/2007, passed by the London District Judge, the case was transferred to the Munshi Namasur Zoha and again suit was registered as Swenso. By order dated Swenso, the London Munshi number 2 decreed the suit. The present defendant number 1 filed appeal before the then District Judge, now Civil Judge, which was registered as title appeal number 18. The appellate court remained the suit. Not dismissed, my lord, it remained the suit for fresh disposal by framing the following 2 additional issues.
Which suit? This was
The 2 additional issues are whether the plaintiff has acquired right, title, interest over the suit land by its sale deed number Swenso. It is, and second, whether the said sale deed number Swenso and rectification deed number Swenso executed by the defendant number 6 in favor of the defendant number 4 are void, illegal and Swenso.
What was decided on these?
Decided that, my lord, issue number two, additional issue. Additional issue number one, Your Lordship, can you see?
At which page?
Page 19, paragraph 25. At the time of argument, learned counsel for the appellant submitted that the plaintiff has failed to prove the execution of registered deed so and so in case number so and so. The certified copy of the sale deed was produced as because he filed the original sale deed in the present suit. And at the time of trial of that suit, record of this case was called for and going through the records of the present suit. The learned trial court in case number so and so held that Exhibit A, the sale deed number so and so is a valid and binding sale deed. Name of the respondent plaintiff was mutated by order dated so and so, passed by the HDC in Miss so and so. Exhibit 2 is the certified copy of the Jomandi. Exhibit 3 to 9 are the revenue received. Admittedly, at the time of execution of the sale deed, vendor could not deliver formal position of the suite land because at that point of time, defendant number 1 is in wrongful positions of the suite land. As such, defendant number 6 could not deliver the first position to the plaintiff. As such, I find that the plaintiff has acquired right title interest suite land by sale deed number 7. How, my lord? Now question is, my lord, sale deed without delivery of positions is not a valid. It should be delivered. Once instantly deliver the positions. Otherwise, it will be not valid, my lord. It is finding that although sale deed has been executed, he is not delivered the positions because other persons are in the suite lands. They are occupying. So how the defendant number 6 will not the necessary parties, my lord?
No, because no relief is claimed against him.
Because, my lord, section 54 TPF defines what is sale, man.
Yes.
It is not necessary the
Delivery of
Correct, my
possession
lord.
is not an,
My lord,
not
but now question
recognition.
is, my lord, whether mutation can be granted while he is not in position, number 1. Number 2, whether that sale is valid without delivery of positions. It cannot be, my lord. Sale will be executed, it will be presumed to be complete when delivery of position is.
from
Right.
where you are saying.
Because
Let him.
because in the plain, we in the written statement, as well as our
No.
evidence, we clearly stated they are not in position not handed over to them.
No. From where you are saying that one of the essential ingredient of sale, completion of sale under Transfer of Property Act is delivery of possession also. From where are you saying?
No, it is a
Read 54.
register deed is followed by delivery of position.
Read it.
As a concerned position.
How much time will you take?
My lord, I will take some time, my lord.
Half an hour.
Half an hour, my lord. My lord, I want to place some status in this point,
Okay.
but
No,
today
we
I
are going to
forget.
complete it. Otherwise, because this is many,
Yes, my
the
lord.
facts are very complex.
Complicated.
If we leave it today, I'll forget everything.
And
Tomorrow
so
I'll,
many suits, my lord,
tomorrow
this
I'll-
suit, that suit, the.
Other matter we are adjourning. You, Mr. Das, you'll be replying.
Yeah, I'll give a reply. It's only on law points, my lord.
my lord, so that since I about to complete, I want to place some judgment, but wrongly I missing some.
You are not ready to.
Not judgment, just judgment. Tomorrow I'll place the judgment.
Let us finish it up today.
I almost finished. Now I'm going to place the sub judgment regarding sale deed and regarding mutation. Because when the person is not in position, they cannot get mutation. I will place some judgment in this point.
Okay. Then
May I
other
please,
matters we are,
My lord, may I please?
other matters will be left.
In
on.
item number 27, my lord, there is some emergency. Can it be placed on 13th of August, my lord, or
Item
any
number
date?
27, what is the urgency?
My lord, the petitioner, the claimant number 1 is, I am being told that she is unwell. So if 13th is not convenient to this honorable court, can it be on 20th of August?
Item number
27.
27 on 20 August.
I am for the respondent, my lord.
Okay.
Somal, depth tomorrow I will.
20, my lord.
We will continue with you because I intend to dictate it in part today itself. At least factual in your presence.
Yes.
Otherwise,
Yes.
This should, that should, that.
I'll be confused.
Yes. It can be done, my lord, but.
On 20th, yes. Yes,
lord.
Mr. Mahmood, anything?
My lord, item 16, we have some urgency. It may kindly be taken on Thursday, my lord.
16. What is the
This is RSA by the same party, man.
same?
That means my learned friend.
Different land.
No, item 16, only one matter, lordship.
You are for the other side.
I am for the appellant. My current senior practice.
Okay, when do you want?
I have no
Thursday,
objection.
my lord. Thursday.
Already prepared, lordship. we can
Several
complete
times
it.
it was listed, but due to
Okay,
different reason,
okay.
it could not be heard.
Thursday we'll see.
Lordship.
Day after
and
tomorrow.
I
Yeah.
have another prayer, lordship. Item 21 also may be fixed on Thursday, lordship. These two matters, lordship. 16 and
16
21.
and 21
16,
Thursday.
21, I am for the respondent. And my learned friend is appearing for the appellant.
Because civil appeal, we cannot fix many civil appeals on.
Lordship, only
If
these two
hearing
matters, lordship.
continues, one item takes too much time. So fixing 30 items is not practicable actually.
Again, adjourning it to someone else.
Because if you adjourn part heard, first part again vanishes. On the next day, they have to start from the very beginning. Though we take notes.
Lordship may fix if lacks favor lordship, then we can complete. Otherwise, it will remain.
Okay, 16 and 20,
One,
21 on Thursday.
lordship. I'm deeply honest.
May I pray, Lordship?
Item 26.
Lordship, I have a prayer, Lordship, item number 23 and 24. This is continuing from 2019. On several occasions, it have been listed. It is not completed part out for a long time. Lordship, this needs an urgent disposal, Lordship.
Yes,
So
it
may
is
I-
first appeal against order.
Yes, Lordship. Lordship, there's an injunction, Lordship.
FAO should not be.
If Lordship peruses the orders.
Okay,
Lordship-
when you want it.
Lordship, on 13, and may I pray, it is being listed as a first item, Lordship,
Mhm.
or at 2. Lordship,
No, add to business.
Lordship, because it is not reaching, Lordship. Or on that day, we can mention and upgrade it, Lordship.
Okay. Okay, on 13.
Lordship.
13 on that day, we'll see what is.
Yes, if it is in the down, it's too far, then I'll make a mention, in the morning.
We'll see on that day. You are free to mention.
Yes. Obliged.
Lordship, item 26, it's an urgent matter, Lordship. Can it be fixed on day after tomorrow?
No, what is the urgency? 26. What is the urgency? Because we have already fixed day after tomorrow some matters. Let it be on 20th, 20.
20.
Item 26 on item number 26. 26 on 20th. Yes.
Worship item number 19. Worship, this matter has been listed after through filing and early hearing IA, Lordship. And last order was there to pray for upgradation also there, Lordship, giving liberty to pray for upgradation. that unfortunately today also left out, Lordship. So.
No, we are helpless because your friend is making a lengthy submissions. When do you want it?
Lordship, it may be fixed 20 or 22nd of August.
22nd.
22nd.
22nd. Oh,
Obviously.
yes. Yes, Mr. Ahmed.
So this is the fact I mentioned. That now some judgment I will produce before Lordship tomorrow or day after tomorrow. Lordship may recorded our submission as well as the facts. And some argument may be left. I will.
Yes.
My learned friend has referred to section 10. Section 10 CPC stay of suit.
Only if the earlier suit is pending.
Yes, so if that suit is pending, so my respectful submission is, my lord, if this in subsequent suit, this out of which this second appeal has arisen, say section 10 is applicable, then in view of pendency of that 64, this suit they ought to have filed an application that there is a
First
higher
stay.
suit, 66 is there, so you stay this suit, whether any such application has been made, my lord.
Okay.
So my lord, the contention of my learned friend that in view of section 10, this present suit ought to have been stayed, my lord, that also doesn't hold water. Now, next, coming to the point, who are defendant number 1 and who are defendant number 2? Now, Lordship will kindly turn to page 74 of the memo of appeal, my lord. That is the written statement filed by 1 and 2, page 74. Also got it, my lord?
Yes.
So this is the written statement which has been filed by the defendant number 1 and 2. Now the defendant number 1 is the appellant before your lordship. Now in this written statement, your lordship, my lord, all along it has been stated about defendant number 1. Who is defendant number 1? How he came in possession of this land. Now, except at para 13 at page 77. Page 77 down below, your lordship will learn para 13. Lordship got it, my lord?
Yes.
Yes. That the statements in para 25 and 26 of the plaint are admitted. Those in para 27 thereof being matters of law do not warrant any reply. It is also admitted that the defendant number 2 came to occupy a part of the suit land as allowed by the defendant number 1. Now, my lord, this is the written statement of the defendant number 1 and 2. Now, what is the pleadings, my lord? Defendant number 1 allowed the defendant number 2 to occupy a part of land. Now, what is the part of land, my lord? 1 kata 4 letters. Now, my learned friend has made a submission that yes, as your lordship has already pointed out, that if this decree is not executable, it will be against defendant number 2. My learned friend says that if it is not executable against defendant number 2, what will be the quantity of land? Now, who is defendant number 2? Now, defendant number 2 came to occupy this plot of land on being allowed by the defendant number 1. So now the defendant number 1, he himself is a trespasser. So whatever right this defendant, assuming that this defendant number 2 as on date is in possession of the suit land or is legal here. Now, whatever right this defendant number 2 will accrue, that right would accrue from the rights which the defendant number 1 have, my lord. Am I clear, my lord? The right which 1 have, that right only 2 can accrue. He cannot accrue any separate right because 1 had allowed the defendant number 2.
Who has expired?
This 2 has expired.
2 has expired.
1 has also expired. His legal representatives has been Well, it's substituted in this case during the pendency of the second appeal. Now, 2, they have said that expired. Now, order 22 rule 10A, my lord. Order 22 rule 10A says that when a party plaintiff 10A, my lord. What you got it, my lord? Order 22 10A, my lord.
Yes.
Yes. Duty of a pleader to communicate to the court the death of a party. Whenever a pleader appearing for a party to the suit comes to know the death of that party, he shall inform the court about it, and the court shall thereupon give notice of such death to the other party, and for this purpose the contract between the pleader and the deceased party shall be deemed to subsist. Now, whether there was any application under 10A which was filed by the pleader or the counsel for the defendant number 1 and 2 before the trial court, my lord?
Okay.
So there was no information before the trial court that 2 had expired. Now, assuming that, my lord, 2 has expired, now what does, my lord, order 22 rule 3 says, my lord? Order 22 rule 4 sub rule 3, my lord. Order 22 rule 4 sub rule 3.
Yes.
Yes. Where within the time limited by law, no application is made under sub rule 1, that means substitution of plaintiff for defendant, where there are more, the suit shall abate as against the deceased defendant. Now, it doesn't say, my lord, say against all the defendant, against the deceased defendant. Now, who is the deceased defendant here, my lord? 2. So, for the sake of argument, let us say that 2 has expired and his legal heirs has not been substituted. So, at best, my lord, the decree will not be executed against the defendant number 2. As a result, the whole suit will not avail. And the judgment which my learned friend has referred, my lord, those are suppose in a joint property, my lord, in a my lord, tenancy. Lordship is aware, my lord. Suppose in a tenancy, my lord, and there are, my lord, 2, 3 owners. Now, any of the co-owner can maintain a suit for ejectment. It is not necessary that all the owners should come and file a suit for ejectment. Any of the co-owners can file a suit for ejectment. Now, in this case, whether 2 was a owner, 1 was merely a trespasser, and in the appellate court judgment, although this question of adverse possession has been taken, my lord, in appellate court judgment, it has been recorded this in cross-examination, the defendant number 1 has stated that he was brought to this suit land as his father was a leasing. That your lordship will find at page 18 of the memo of appeal. Page 18, my lord. Of the memo of appeal, that is the judgment of the appellate court. Now, I mean, page 18.
Yes.
Yes. Clause, para 23 down below. In TS, what you found it, Mala? In TS 6694, the issue 3 was whether the defendant number 1, present appellant, has been possessing the suit land since so and so adversely acquired right title interest over the land in that suit. Defendant number 1, present appellant, filed his evidence on affidavit as DW2. In his written deposition, he has stated that he and this predecessor has been possessing the suit land for last 70-80 years by constructing dwelling houses. During cross-examination, DW2, that is the appellant here in my lord, has stated that his father had taken the suit and suit land on lease from the father of DWC's Biren Count and so and so, late so and so at yearly rent of ₹3. His sister so and so brought him to the suit land and look after her as she had no children prior to coming to the suit land. He was residing at so and so. He had been residing over the suit land for last so and so years. The trial court held the defendant number 1 has categorically admitted this father was a leasee under the original owner of the suit land at an yearly rent of so and so. It is therefore an admitted fact the defendant number 1, by stepping into the shoes of his father has also acquired the status of a leasee in respect of so and so, hence the defendant is a permissive occupier of the suit land and under the original owner of that land on payment of rent. Learned Trial Court has also held that it is an established principle of law that a permissive possessor cannot set up a plea of adverse possession. Thus, the issue was decided in negative against the defendant number 1. So, his contention that he has acquired an adverse title, my lord, over the suit land, my lord, that has also been negated. And this defendant number 2, on what he has done, my lord, he has only filed this written statement along with the defendant number 1. Apart from that, my lord, this defendant number 2, neither his legal representative have ever adduced any evidence before any in these proceedings, nor have assailed any orders passed in this case before any court. And my instructions are that this he has, my lord, he was, my lord, this Kaviraj means administering this, my lord, allopathic medicines. After his expiry, he had one daughter, he's been married off, and as on that, only one is in possession of that suit land. So that being the position, my lord.
Suit land is a basti land.
Residential.
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 Yes.
Residential. area.
Residential.
My friend says, if a person that, how can he take steps? Person already expired. How can he take steps in the suit?
I have never
How can he
seen
lay
that.
evidence, my lord? How can he lay evidence? Come to the court.
No, no, he's
So I
saying
have,
the council has a duty to inform the court.
yes, that is one aspect. And assuming that yes, the legal representatives are occupying, he has expired, his legal representatives are occupying that plot of land. In that event, as the defendant number 1 is contesting the suit, why 2 is not contesting?
It is.
My lord,
It may be-
justice, my lord, has to be seen to be done. So your lordship will kindly appreciate, will leave it the veil and see what is the reason why this defendant number 2 or any one of his legal representatives have never approached any court of law assailing any order passed in any of the proceedings, madam. And I have lent my books to my learned friend. Sale, my lord. Section 50, lordship is well aware, my lord, your lordship has vast experience. I need not, my lord.
What 54 says?
54 says what is sale, my lord? Sale is transfer of ownership for consideration. I will just read it. My lord.
So transfer of handing over of possession is not necessary.
My lord, 54 doesn't say so. My lord, 54 sale defined. Sale is transfer of ownership in exchange for a price paid or promised or part paid or part promised. Sale how made? Such transfer in case of tangible immovable property of value of 100 rupees or upwards, or in case of reversion or other intangible thing, can be made only by registered document. Then, my lord, section 17 of the registration act. In case of tangible immovable property of value less than 100 rupees, such transfer may either be made by a registered instrument or by delivery of property. My lord, this nowadays, my lordship will not get any property, the value of which is below 100 million. So, my lord, sale is defined under section 54. Sale means transfer of ownership for consideration. So, my lord, just because this possession was not handed over, so my respectful submission to your lordship would be, my lord, it would not be a case just because this my lord, possession was not handed over, so sale is not done. Now, regarding, my lord, mutation, my lord, lordship knows, my lord, mutation does not confer any title. It is only to facilitate payment of land revenue. So, my lord, there
In whose name it has been mutated? Your name?
it has been mutated in my name.
Okay.
So,
But if that is a different chapter.
that is a different chapter. Suppose
You
tomorrow
could
your
have
lordship,
appeal.
yes, there under land revenue regulation, there is a procedure for appeal and all those things. But even today, suppose, as my learned friend has submitted that regarding mutation, the lordship says that yes, mutation could not be made. Will it affect my title? My respectful submission it will not, because it is only to facilitate payment of land revenue. It doesn't, mutation have nothing to do with my lord title.
Okay.
So in sum and substance, my lord, these are.
If you have any submissions, we'll fix it when? Tomorrow or day after tomorrow?
Day after tomorrow, my lord,
Day after tomorrow, we'll fix it.
my lord, I make some submission. And there is a
Let me
also,
dictate the facts.
Yes,
facts is lordship, but only fact, my lord.
Not now, day
Uh,
after tomorrow.
yes.
You continue day after tomorrow.
Issue number
Heard
7 and other issues are there.
Heard Mr. J. Ahmed. Learned. Counsel for the appellant. Also heard Mr. A. Das. Learned counsel for the respondents. This regular second appeal has been preferred, has been filed under section 100 of the Code of Civil Procedure, 1908 by the defendant Abdul Hamid. No, by the appellant Abdul Hamid, within bracket Ghori Mistri, impugning the judgment and decree dated 21/12/2013, passed in title appeal number 5/2011 by learned Civil Judge Jorhat, whereby it upheld the judgment and decree dated 28/2/2011, passed by learned Munsif number 2 Jorhat in title suit number 15/2017. Stop. In effect, the appeal preferred by the, in effect, the first appeal preferred by the present appellant was dismissed by the first appellate court. The facts relevant for consideration of the instant second appeal in brief are as follows. That
One thing, my lord, appellant expired in his place, there were substituted.
appellant expired
Expired in
during
the
first
meantime.
time.
Here.
Okay.
And their legal, yes, were
Representative was substituted.
substituted.
So it is before that. It is pertinent to mention herein that during the pendency of this second appeal, appellant Abdul Hamid expired and by order dated 24/2/2023, the legal heirs of the appellant, namely 1 Abdul Mateen, 2 Abdul Waheb, 3 Abdul Rauf, 4 Abdul Rafiq, 5 Rumena Begum, 6 Rukia Begum, and 7 Ruli Begum were substituted. তাৰপিছত ক'ব the facts relevant for consideration of this appeal in brief are as follows. That the, how many defendants are there? Respondents are there?
Only one moment. Sole defendant. Pro forma was there, but
Not really.
only sole defendant.
That respondent number 1 in this appeal, namely Ram Nagina Gupta, had filed a title suit for declaration of right title and interest and for cancellation of sale deed also.
Yes. Sell deed and rectification deed, subsequent.
Yes, yes.
Cancellation
Page
of
72.
cancellation of sale deeds and for recovery of khas possession of the suit land measuring 1 katha,
4 letters.
4 lechas,
Page 72 down below.
1 kathas, 4 lechas of land covered by periodic patta number 268, dag number 3617 of block number 1 Jorhat town which is more particular, which has been fully described in the Schedule A to the plaint filed by the plaintiff. The claim of the plaintiff before trial court was that the defendant number 6, the defendant number 6, namely Biren Khan, had sold the suit land to the respondents / plaintiff to the plaintiff on 30/11/1978 by executing a registered sale deed number 9295 dated 30/11/2007, 1978. It was also pleaded in the it was also averred in the plaint filed by the plaintiff that the defendant number 1, namely Abdul Mahmid Ghori Mistri, within bracket, the appellant in this case, was in wrongful possession of the suit land at the time when the sale deed was executed, and hence the plaintiff would not take over the possession of the suit land after execution of the sale deed. The defendant number 1 and 2 in this said suit, namely Abdul Mahmid within bracket, present appellant, Abdul Hamid within bracket, present appellant, and defendant and Alauddin Hakim within bracket, Kabiraj, filed a joint written statement wherein they took a plea of adverse possession. What plea they took?
They said that they have been possessing this land for a long time.
Wherein they took the plea that they were in possession of the suit land since a long time. It was also averred in the written statement that defendant number 2 came to occupy a part of the suit land as allowed by defendant number 1.
And claim adverse possession also.
Adverse possession you have claimed?
Yes.
Where?
Yes, since Possession has been since 1971, exceeded the statutory period, and the defendant number one has acquired the title given by advance possession.
A line to keep
And,
clear.
and claim position.
Before that. Both of you may take your seat.
Yes.
They took the plea of adverse possession. They took the plea of adverse possession by stating that তাৰপিছত কি আছিল? No, they were in the possession over the suit land since long time. Stop. It was also stated in the written statement that defendant number 2 came to occupy a part of the suit land as allowed by the defendant number 1. Stop. On the basis of the pleadings of the parties, the trial court framed following issues. Where are issues? At page 12.
Yes. Question, let's put judgment from the issues.
Page 12.
Yes.
Following issues. Number 1, whether the plaintiff has any cause of action for the suit, question mark. Whether the suit is barred by limitation, number 2. Number 3, whether the suit is hit by principles of estoppel and of waiver. Number 4, whether the suit land is also subject matter of title suit number 66/94. Number 5, whether the suit is maintainable in law in view of counterclaim taken by the plaintiff in title suit 66/94. Number 6, whether the pro forma defendant number 6 had been the absolute owner of the suit land and whether he had right to sell the suit land to the plaintiff. Number 7, whether the defendant number 1 acquired the title by adverse possession over this adverse possession. Stop. Number 8, whether the plaintiff is entitled to relief as prayed for. Number 9, to what reliefs the parties are entitled to.
Two additional
issues are also down.
It is
In
pertinent to mention herein that the title suit number, what was the number? 177 of 1994.
Ring number is 15 of the 07.
The said title suit was transferred by the learned District Judge Jorhat to the Court of Learned Munsif number 2 Jorhat. And on its transfer, the suit was renumbered as title suit number 15/07. Stop. Thereafter, by judgment dated 16/7/2007, learned Munsif number 2 decreed the suit. Stop. The present appellant present appellant, but the predecessor in interest of present appellants. আগতো চেঞ্জ কৰিব লাগিব predecessor in interest পিছত কৰিম no predecessor in interest of the present appellant filed an appeal against the said judgment before the court of learned assistant district judge which was registered as title appeal number 18/2007. The said appeal, the appellate court remanded the suit back to the trial court for fresh disposal after framing two additional issues. Stop. The two additional issues which were framed were as follows. Number one, additional issue number one, whether the plaintiff has acquired right title and interest over the suit land, White sale deed number 9295/2000/1978, dated 30/11/1978. Additional issue number two, whether the sale deed number 4484 date/1978, dated 29/12/1978, and the rectification deed number 100/80 dated 14/1/1980, executed by defendant number 6 in favor of defendant number 3, 4, 5 are void, illegal, and liable to be cancelled. Thereafter, the learned Munsif number 2 again heard the suit afresh and passed the judgment on 28/2/2011, again declaring the suit. Stop. Next paragraph. Being aggrieved by the judgment and decree dated 28/2/2011, the predecessor in interest of the present appellants again preferred an appeal before the Court of Learned Civil Judge Jorhat, which was registered as title appeal number 5/2011. The said appeal was dismissed by judgment dated 21/12/2013, affirming the judgment and decree passed by the trial court. Stop. Being aggrieved by the judgment of the trial court, aggrieved by the judgment of the first appellate court, the present regular second appeal has been preferred by the predecessor in interest of the present appellants before this court. Stop. It is pertinent to mention herein that, stop. It is pertinent to mention herein that in respect of this same suit land, which is the subject matter of, which was the subject matter of title suit number 15/2007. The defendant number 345 of title suit number 15/2007 had preferred a title suit earlier before the court of which court?
It comes in about 66.
Before the court of Dash, which was initially registered as title suit number 75/1983 and subsequently renumbered as title suit number 66 of 1994
Assistant District Judge, Jorhat.
before the court of Assistant District Judge Jorhat. In the said suit, the predecessor in interest of the present appellants was arrayed as defendant number 1 and Alauddin Hakim was made defendant number 2. And the respondent of the present appeal, respondent number 1 of the present appeal, namely Ram Nagina Gupta, was made as defendant number
6.
6.
Six.
Pro forma defendant number 6. 6. Stop. The said suit was dismissed on 29/3/2005. Who preferred appeal? Title appeal 19.
This Kundalia brother, this in 66 against
66.
this Kundalia brothers, that is 3, 4 and
Against
5.
being aggrieved by the order of the dismissal, the plaintiffs of the said suit, namely Bhaurilal Kundalia, number 1 Bhaurilal Kundalia, number 2 Bikram Chand Kundalia, and number 3 Rajkumar Kundalia, preferred an appeal which was registered as title appeal number 19/2005. The said appeal was also dismissed on 8/8/2006.
66.
6, whereby the judgment dated 29/3/2005 of the trial court was upheld. Stop. Stop. Next paragraph. It is pertinent to mention herein that the earlier suit, that is title suit number 66/1994, was filed by the plaintiffs Bhaurilal Kundalia, Bikram Chand Kundalia, and Rajkumar Kundalia, claiming right title and interest over the suit land on the basis of a sale deed which was executed in their favor by Biren Khan on 27 on 27/12/1978, bearing sale deed number 4484, dated 27/12/1978. In respect of 1 kotha 14 lechas of land covered by dag number 3686 of periodic pata number 268, which was more fully described in the schedule to the plan. The schedule of the land mentioned in the said sale deed was rectified later on by Shri Biren Khan by executing a deed of rectification on 14/1/2080, whereby the area of land mentioned in the sale deed number 4484 was rectified from 1 kata 14 lechas to 1 kata 4 lecha, and the dag number was rectified from 3686 to 3617. Stop. In this regular second appeal, after perusal of the memo of appeal as well as documents annexed thereto, this court, by order dated 23/5/2014, formulated following substantial question of law. Number 1, whether in view of withdrawal of title suit number 30/1980, while a counterclaim remained on record, the subsequent suit of the plaintiff was barred. Number 2, whether the suit of the plaintiff had abated in view of the abatement of suit as against the defendant number 2. Number 3, whether the learned courts below committed error in declaring title of the plaintiff over the suit land. Stop. The substantial question of law number 1 formulated by this court, substantial question of law number 1 formulated herein above was reformulated again by order dated 23/7/2024 by as in following manner, within inverted commas. Whether in view of dismissal of title suit number 95/1983, these numbers are correct, 95/1983. Because this, I am not getting any.
95, 75 of it, this regarding 66 of 94 only.
It has to be 60.
Yes, initially it was 75 of 1983, Then
It was 75 or 95?
75.
75 of
75,
83.
1983. Then it was renumbered as 66
66.
of 19.
75 of 1983, which was renumbered as
66
title
of
suit number 66 of 1994, comma, while a counterclaim filed by the present respondent slash no, this requires reformulated formulation again. This was wrongly because counterclaim was not filed by plaintiff.
yes.
Counterclaim was filed by respondent number 6.
Yes. Now,
Ram
here
Naik.
is also my note regarding this respondent, it will be 5 or 6. Here,
There's a
what
4
they
in
have-
twice.
4 has been written twice.
Twice. That is
If
why
you-
you are just number 5.
That is why.
Then we may
Lordship,
instead of using numbers, we may use
yes,
names.
because I got confused and in this chart also I have written 6 because serially if we go, this
will be
Ramnagina
6.
will be 6.
6,
6.
but the
Four-
judgment everywhere it is used as 5.
Why it is used as 5? Because
4 has been mentioned.
4 has been mentioned
Twice.
twice. So that is this Ramnagina becomes 5. So I serially I have marked it as 6, but 4 is twice. That is why. That is why by name will be.
That's not a public file.
No, into reformulation key volumes. No, তার আগর প্যারা।
Plaintiff তো হয়ে গেছে।
Counter claim only 6. Ramnagina.
Plaintiff. Application of plaintiff.
No.
Because the
Substan-
plaintiff Ramnagina is
Substantial question of law. Reformulate. No, last paragraph. Huh? Into কাটি দিও। The substantial question of law formulated herein above is reformulated again as hereunder. Whether in view of dismissal of title suit number 75/1983, which was renumbered as title suit number 66/1994, wherein a counterclaim filed by the present respondent, namely Ramnagina Gupta, remained on record, comma, the subsequent suit by the respondent, subsequent suit,
Respondent plaintiff.
respondent plaintiff, correct, yes. Respondent plaintiff,
Ramnagina.
namely Ramnagina Gupta, was barred. Stop. I have heard learned counsel for the appellants as well as learned counsel for respondent and have perused the materials on records, including the records of the first appellate court as well as the trial court, which were requisitioned in connection with this case. Learned counsel for the appellant has submitted that on perusal of the written statement filed by the predecessor in interest of the present appellants, namely Abdul Hamid, and who filed the counterclaim?
Their contention is that Ramnagina
Okay,
filed.
okay.
Plaintiff, public respondent.
No. Perusal of the written statement filed by the pro forma defendant number 6, namely Ram Nagina Gupta within bracket present respondent in title suit number 66/1994. It would appear that itu recorded rakho.
No, it is already on record. It is.
Record room major. It would appear that he had filed, along with the written statement, he also filed a counterclaim praying for declaring that the pro forma defendant is pro forma defendant, namely Ram Nagina Gupta, is entitled to khas possession over the suit land after evicting defendant number 1 within bracket Abdul Hamid and defendant number 2, namely
Alauddin Hakim.
Alauddin Hakim. On the basis of his right title and interest over the said land. Stop. Learned counsel for the appellant has submitted that though by judgment dated 29/3/2005, the title suit number 66/94 was dismissed. However, no order was passed with regard to the counterclaim filed by the present respondent, that is the Ram Nagina Gupta. Learned counsel for the appellant has submitted that as the subject matter of the suit in the title suit number 66/94 as well as title suit number 15/2007 where same the subsequent suit, that is title suit number 15/2007, was barred by res sub judice as provided under section 10 of the Code of Civil Procedure. And hence, in the subsequent suit, that is in title suit number 15/2007, decree could not have been passed in favor of the present respondent Ram Nagina Gupta. You will
Regarding to, I will place some judgment.
we should stop here
Yes,
now.
yes, madam.
Your
Submissions.
I'll dictate it in chamber.
As your lordship.
As your lordship, regarding advice position, and some I will make, and some decision I will make, I will place your lordship.
लिखी रखो, पिसोर मिलेगा. On the other hand, learned counsel for the respondent has submitted that though in the written statement filed by the present respondent in title suit number 66/1994, he had prayed for what was prayed?
For declaration.
No, not declaration. He
Declaration.
had prayed for the delivery of khas possession in his favor by evicting defendant number 1 and 2 on the basis of his right title and interest over the suit land. However, the said written statement was never treated by the trial court as a counterclaim. He also submits that, learned counsel for the respondent also submits that a counterclaim cannot be filed against a counterclaim has also submitted that under Order 8, Rule 6A, a defendant in a suit may, by way of a counterclaim, may file a counterclaim against the claim of the plaintiff. However, same may not be done against any of the defendants. Hence, the written statement filed by the any of the defendants stop. Hence, he also submitted that in case of a counterclaim filed under Order 8, Rule 6A, same shall have to be treated as a plain for all purpose and same shall have to and same is governed by the rules which are admissible to plains. Stop. He further submits that in the said title suit, the defendant, the present respondent, as pro forma defendant while filing the written statement, never filed any court fee for the counterclaim, and hence he submits that the written statement filed by the present respondent in title suit numbers 66/94 may not be treated as a counterclaim. And therefore, the bar of section 10 of the Code of Civil Procedure may not be applicable in this case.
My lord, will kindly refer to that order also, it will be clear, my lord, that this orders a flag mark, my lord, that the 10-8. Yes, 10-8-84, because when this written statement was filed,
Learned counsel for the
respondent,
respondent has also submitted that on perusal of the case record of title suit number 66 of oblique 94, it appears, it becomes clear that when the written statement was filed by the present respondent in the said suit, the next date, the said suit on which date?
it is flag mark 10-8. 10-8-94.
On 10-8-1998.
84, I think.
No, sorry, 10-8-1984. The order sheet does not mention anything about the counterclaim, and the written statement submitted by the present respondent was referred to as written statement, and next date was fixed for framing of issues.
And no date was fixed for filing of WS.
He also submits that had it been treated as a written statement,
As a
next
counter-
date would have been fixed for filing of written statement against the counterclaim by the plaintiff side.
Had it been fixed as a counterclaim, what she was dictated, had it been this had it.
Perhaps.
eh,
Had it been treated as a
Counterclaim.
counterclaim, had it been treated as a counterclaim,
Counterclaim.
আর উপর।
Then it's okay.
Had it been treated as a counterclaim, written statement to কাটি দাও। Officer?
Then
No, next date would have been fixed for filing of written statement
Against counterclaim.
against counterclaim
counterclaim.
by the plaintiff side.
Right.
Stop. Anything else?
But from the record, it doesn't transpire that court has fixed.
He also submits that from the entire record of title suit number
66-94.
66/94. From nowhere there is mention that the written statement filed by the present respondent in the said suit was treated as a counterclaim at any point of time for any purpose. Stop. Anything else?
This point is covered.
Next, we will continue day after tomorrow. Itu বেলেগকে ৰাখিব আজিৰ order হ'ব heard Mr. J. Ahmed Lanet counsel for the appellant, also heard Mr. A. Das Lanet counsel for the respondent. Hearing remain inconclusive. List this matter again as part heard matter on 8th of August at 2 p.m.
Yes.
Otherwise, it may not
Otherwise,
reach
that is why.
at
So,
2 p.m.
At 2 p.m. My lord, this copy of plaint, I have only this copy. This is already on case record, man.
Okay,
This is,
you return
yes,
your GSA to ঘুরাই দিবে।
but only this one. Because these papers are also so fragile, my lord, it
Yes, yes.
falls in
It is,
pieces.
starting from 78, 80, from 84.
You, Mr. Ahmed, you take back this,
Yes,
Judgments.
I'll place.
you place it on next day.
Yes, ma'am.
Any judgment?
And that,
To, eto ঘুরাই দিন।
and appellate copies.